Good afternoon. Okay. So good afternoon, everyone, and welcome to the Appellate Division, First Department. We have close to 6 hours of argument time scheduled, requested for this afternoon. So please bear that in mind as I call the calendar and ask only for the time that you need to make your most important arguments. Understand that we have your briefs, we have the record, and we're fully familiar with the facts of your cases. Before I call the calendar, I want to welcome a couple of groups. First, we have some interns here from the AD1 Summer Intern Program. We have a few law students led by one of our court attorneys, Alan Gray. I see them over there. We also have some interns from Judge Ellen Biben's Summer Internship Program. Judge Biben is the supervising judge of the New York State Supreme Criminal Term of New York County. I'm not sure if they're here yet, but hopefully some of you are here. Okay, terrific. And you are led by Special Projects Coordinator Kelly Duffy. Thank you for escorting the students here. And finally, we have some summer interns from the Steptoe Law Firm, and they are with attorney Dina Coker. There you are, Dina Coker. And good to see you all. Thank you for being here. And well, we hope that there's nothing that will discourage you from the practice. Nothing you see here. Hopefully, all you see will be very instructive and interesting. And finally, although this does not end our work, this is our last sitting for the term. So if I waited till the end to say this, there would only be 2 attorneys here. So I wish you all a very healthy and restful, restorative, and enjoyable summer. We will be working still, of course, taking applications and such, but this is our last sitting for the term. Okay. And with that, People versus Rashad Jackson, submitted. Frankie Z versus Jessica R, that's submitted. White versus Vaccaro. You just want 3 minutes.
3 minutes is fine.
Four, 2, and 3. Rahman versus the City of New York. Uh, 3, 2, and 5. G Unit Books versus Tompkins.
Good afternoon, Your Honors. The appellate requests 4 minutes. Choose rebuttal, please.
Good afternoon, Your Honors. For the defendant, respondent, 10 minutes, please.
4, 2, and 4. Williams versus RXR Construction.
Good afternoon. Appellate respondent requesting 7 minutes.
Who do you represent?
RXR Construction. Appellate.
And you ask for?
7 and 2, please.
I'll give you 5 and 2. If you need more time, we'll allow it.
Good afternoon, National Wall respondent requesting 5.
Yes?
Good afternoon, Your Honor. Plaintiff respondent requesting 4. Good afternoon, Your Honor. Defendant RXR SL owner and RXR Realty. We're going to be relying on.
Okay. Your Realty, you're going to rely on your brief? Okay.
Respondent Super G requests 3 minutes.
Okay, RXR Construction, 5 and 2, National, 3 minutes. Plaintiff, 4 minutes. United Glass, 3 minutes. Super G, 2 minutes. If you need more time, I'll allow more time. Okay? Thank you very much. American Transit Insurance versus Mark Heiligers, submitted. Malia M., submitted. Hamapur versus 3M Properties LLC,
Good afternoon, Your Honor. For appellant 9 and 4.
Good afternoon, Your Honor. For the Varunian respondents, 5.
6 and 1, 5 and 3. 6 and 2, 5 and 3. Edward Roberts LLC versus Shipman and Goodman,
Good afternoon, Your Honor. Appellant cross respondent Shipman 8 and 4, please.
Good afternoon, Your Honor. For plaintiff respondent appellant, 8 and 4 as well. Prosecutor.
I'll give you 6 and 3 and 6 and 3. NFL versus U.S. Specialty is submitted. Vargas versus 250 West 43rd owners,
Good afternoon. Defendant appellants Park Premium and Park Developers requesting 5 and 2.
Plaintiff respondent requesting
5, 2, 4 and 2, and plaintiff 4 minutes. Thank you. Dwayne versus Nisha, and I'll take them separately. And then, I'm sorry, then you also have Elliott Chelsea House's residence. And you're going to cover both appeals, correct? Both of you? Count? So where is, okay. Okay. I'll say 10 and 2 and 10 on all cases. If you need more time, I'll give you more time. All right, we are going to start with ten minutes and you a total of 10 minutes. Are you going to argue each case separately? If you want, okay, all right. All right, I'll give you 5 and 2 and 5 and 2, okay? 5 and 2 and 5, you're not, 5, 2 and 5 and 5, 2 and 5 for each case. So you would get your 5 and 2 and you get 5 and you get, okay? All right, thank you. We're going to start with the last 2 cases first, so I'm going to start with numbers 13 and 14, the last 2 on the calendar. So Dwayne versus Nisha. And Judge Rosado is recused from those cases. Okay.
Good afternoon, Your Honors. John Lobert for appellants. Under the plain meaning rule, the literal unambiguous language of a statute is controlling unless that language would defeat the statute's plain intent and
Counsel,
purpose.
I'm just, Counsel, just maybe if you move the mic or stand in front of it a little bit more, let's try that, because, and just begin again with your appearance and
Sorry, it's
everything.
loud or? Oh.
No, it wasn't clear enough.
Oh, it's
so-
not clear. Okay. Under the plain meaning rule, the literal unambiguous language of a statute is controlling unless that language would defeat the statute's plain intent and purpose or lead to an absurd result. The meaning of the statutes here, Charter Section 197C and Public Housing Law 402B, is absolutely clear, and their application does not defeat.
You have to stay in front of the microphone. If you drift away, yeah. It's where it is. You don't have to move it. You have to move yourself. Yes.
I'm sorry, does not defeat the statute's intent or lead to any absurd result. Yet NYCHA invokes context. Appellants are NYCHA residents and their supporters. They recognize that NYCHA needs more funding. They're certainly not NIMBYs, but this massively destructive plan is a bridge too far. Privatizing and demolishing public housing is harmful, unnecessary, and violates Housing Law Section 402B.
Counsel, did the statute of limitations here run
No,
for your?
it did not.
And why not?
Oh, okay. Well, I thought that was kind of a frivolous point, but I'm happy to go into it. There are many reasons why it did not. First of all, that was a SECRA finding statement. SECRA is completely irrelevant to this case. There is no SECRA claim in this lawsuit. There's no land use action in the resolution that we are
You
challenging.
have 4 months to get, for an Article
It
78.
is 4 months, yes.
You have 4 months
Yeah.
from the date of the decision.
Yes, and the decision.
Isn't this past? Yes, go ahead.
And the decision was September 18th, 2025.
That's the decision that you're seeking, but what about the July decision?
Yes, we do not, we would argue that that decision is completely irrelevant to this case. We listed about, I think it was 8 reasons or 7 reasons why the statute of limitations has not run. And I don't believe in.
That's the record. Sorry, that's the record of decision. That decision put forth the decision and the facts, and with regard to the redevelopment, and it was, distributed to the public and everything else. So I'm not quite sure why you believe that that date should be ignored, and we should follow with the September date, which I understand it was a later date, and it was the board resolution, but the decision had already been made with the July record of decision and the facts.
Your Honor, we would contend that no decision was made at that time. A finding statement in a.
It was a record of decision and finding of statement.
Right. Record of decision and finding statement. But under SECRA, a findings statement is not decisional. And moreover, all it says, it has a paragraph in it with the heading decision. It says in that paragraph that they were choosing the preferred alternative over other alternatives. We're not.
Didn't once they issued that decision in July of 2025, on the very same day, NYCHA began issuing mandatory relocation notices and began relocating tenants, and things started to move from that date. So why would that not be the date from which we measure the 4 months?
We contend that those actions were illegal, contrary to HUD rules, contrary to NYCHA's own relocation plan.
Counsel, the July 28th, 2025 record on decision was issued by the agencies and it required some kind of action, or is that, obviously you're taking the opposite position, but can you just explain why? Because when we talk about Article 70, when we talk about Article 70 as in the 4-month, we talk about agency action. Why wasn't that the operative date?
Well, because this was not even an agency action. It was signed by the chief capital, what the title
It
means.
was NYSHA
The
and
CACMO, the Chief Asset and Capital Manager.
NYSHA and HPD issued a joint record of decision and a findings statement.
Right.
So just trying to figure out, why was that not a decision from an agency?
Because it was never adopted by NYCHA's board. It is totally irrelevant to the claims we're asserting here. It had nothing to do with the case. It was not the final approval of this plan. It only concerned at most.
Counsel, isn't it true that the September 18, 2025 date was not even raised below? You didn't argue that was the date of accrual before the court?
That is correct. We did.
How do you do it now? Isn't that unpreserved?
We would argue that it's not unpreserved.
Is that document in the record?
Yes, absolutely. As I believe the court knows, we sought a temporary restraining order, which this court granted based on documents that we submitted to the record. We contended that NYCHA is judicially and equitably estopped from raising its statute of limitations argument by virtue of the fact that it previously argued that that a previous decision in the Weaver case, which we've titled as Weaver 1, it was before this court on the motion for interim relief, and in that decision, the court stated that an action raising the same claims that we raise here was not ripe and would be ripe when the board issued the NYCHA board, not its chief asset and capital management officer, but the board issued a
not sure,
resolution authorizing conversion and a 99-year lease.
Okay. Is there anything else?
Okay, may I continue, or?
I'll give you a few minutes to make.
Okay, thank you. I wasn't really, okay, I mean, there are many reasons I thought we dealt with this at great length in our briefs, and so for the statute of limitations point, I will rely, in addition to what I said here, obviously I rely on what we said in our briefs. So we recognize that NYCHA needs more funding, but we would contend that privatizing and demolishing public housing is harmful, unnecessary, and violates public housing law, section 402B. And HUD's own study of the RAD program, this plan is being executed pursuant to HUD's RAD program, but it could be done without privatization. 3/4 of the public housing authorities in the nation that have executed RAD conversions have done so while maintaining control by the public housing authority. And that's what 402B allows NYCHA to do. It allows nominal privatization. It allows access to federal and private funding while maintaining public control. And although the low-income housing tax credits that NYCHA used in 2010 when that law was passed have now expired, NYCHA could once again raise additional funds for rehabilitation through a resyndication under 402B.
Okay, I'll let you finish up anything else on.
All right. I just want to say about ULURP, our other claims. So our first claim concerns violation of Section 402B, which doesn't allow privatization. Our second claim concerns the requirement that NYCHA submit this plan to ULURP, which it characterizes an unnecessary, highly politicized legislative review process that enables NIMBYism and opposition to public housing, but actually ULURP has been used to obtain funding for NYCHA. There were in the Gowanus rezoning, Brad Lander obtained $216 million.
Why is ULURP required in this
Yes.
instance?
It's required for any plan or project that's federally funded for any housing plan federally funded as defined, a plan or project as defined in the public housing law. It definitely
Okay,
requires.
thank you very
it.
much. Thank you.
All right.
Here from the other side.
Thank you.
Thank you, Your Honors. Elizabeth Bauer for respondents.
Again, I'm going to ask that you speak up and put the mic, yeah, so that we
Does
can.
that
hear.
work?
That's much better.
All right, thank you. I think the court's quite familiar with the record regarding the statute of limitations, but I will just note for clarity's sake that on the first page of the ROD, it states, "This ROD and findings statement documents the findings and decision to proceed with the proposed project," which was the redevelopment.
Why the board, why is the board resolution, why the board resolution? Why isn't the board resolution before, you know, it goes out to the public? Why isn't that final? They're saying it's final, and the board is adopting it.
Well,
Why
we're
wasn't-
not arguing that the board, that any of the three board resolutions that approved aspects of the transactions were not final, but the final,
In other words, why wouldn't one of those be the dates that the statute of limitations runs
You
from?
mean the earlier board resolutions? in
Exactly, the one that's,
2021?
no, I'm talking about September 18th, 2025, what followed. Why wouldn't that be the date to begin the 4 months?
The July 28th, 2025 ROD was what began the 4 months because it was it declared NYCHA's final decision to undertake the redevelopment. The September 18th resolution doesn't restart the statute of limitations. There can be many steps involved in a complex project, and as the Riverkeeper versus Crotty case recognized, that just because there are further steps to be taken does not eliminate the finality of an initial decision.
So you're saying that the board resolution of September 18th, 2025 just began one aspect of what the RAD had already determined. In other words, the RAD determined the entire length of all of the aspects of the project, and the board resolution just spoke to the first step of that was to take place?
The board resolution authorized NYCHA to undertake certain actions with respect to the first phase of the redevelopment. But
The first
the
phase.
ROD declared NYCHA's decision to undertake the redevelopment as a whole. It also reflected the earlier board resolutions, which had already determined and made clear, and NYCHA had already been challenged on this in prior proceedings, that NYCHA did not intend to undertake a public housing law section 150 review process with respect to the redevelopment as a whole, and also that it was proceeding with the redevelopment, or it would proceed with the redevelopment, notwithstanding PHL section 402B.
Is the board resolution in the record?
The board resolution is not in the record on this appeal, Your Honor. When we appeared for oral argument, which is the last part of the record on the preliminary injunction motion, apparently appellants were not aware of the September 18th resolution, which is another reason why it doesn't make any sense that that could start the statute of limitations for this challenge, because when they brought the challenge, they didn't even know about it. So, but they did not mention it at the oral argument, which was essentially how they replied to our opposition to their preliminary injunction motion. It was only later in time that they stated that they had learned of it, although it was available on NYCHA's website all along.
Did you conduct a ULURP? And if not, why not?
No ULURP has been conducted for the redevelopment as a whole and is not needed for the first phase, which doesn't require any zoning changes. The appellants argue that ULURP is required under Public Housing Law Section 150, which applies to new plans or new housing developments that a public housing authority is undertaking. And here, there's several reasons why it doesn't apply. If you'll bear with me, I'm sorry. The redevelopment is not a plan within the meaning of the public housing law because it does not involve the clearance of a substandard or insanitary area. It is therefore not a project within the meaning of the public housing law because it is not a work or improvement to effectuate a plan. Rather, the redevelopment is a replacement of the same number of units in existing projects that were built decades ago in accordance with approved plans. So the required process under PHL Section 150 was undertaken in the mid-20th century for approval of these public housing projects.
But isn't part of the plan going to include additional buildings with mixed use? And so there were going to be more buildings than there are now?
Not NYCHA buildings. NYCHA will be changing the existing units into...
And the zoning, and changing the zoning also?
The zoning, NYCHA will undertake ULURP for zoning actions that are required for the later phases.
And what phase is that?
So definitely for the last phase, which is the additional units. The additional units will be subject to ULURP because of zoning changes, not because of
And
public housing law.
the additional units are the mixed-use units?
That's correct.
Not the units that the NYCHA, those tenants who are in and going to be removed
Exactly.
under this
Yes.
project are going to be returned to?
Yes, the
Let
plan
me
for
just
the...
ask, of the NYCHA buildings, not the mixed use, is there any zoning that's going to be changed in those NYCHA buildings?
For the second phase, it is likely that there will be zoning changes required. So for the second phase, assuming that's the case, that will go through ULURP.
Will the additional buildings be developed on land belonging to NYCHA?
Yes, and it will remain in NYCHA's ownership. However, that is, it will not be part of the current, the approved plan. It will be a separate...
So how do you address the argument of your friend that it violates the Constitution Article 18, which requires that the land be used for persons of low income?
I think that's actually an argument that the other appellants are making, but I'm happy to
Okay, I'm
address...
mixing up both? Okay, thank you.
I have been
That
mixing them
interests
up
me the
as
most.
well.
At least,
So I'm happy to
no, if it,
address
I
that.
apologize. I'm mixing up the two.
But in terms of the PHL 150 claim, I think the Court of Appeals has addressed the application of PHL Section 150 to a change in a plan that was previously approved in the Margulis versus Lindsay case, which held that Section 150 should not be broadly applied to changes in building form and arrangement to already approved projects. The court in Margulis warned that such an application would invite the public to weigh in over and over again through a political process on the appropriateness of low-income housing, which is exactly what the appellants are seeking to do here. The non-essential changes to an unbuilt plan in Margulis were actually quite perfectly analogous to the changes that the redevelopment will effectuate here with respect to the existing NYCHA buildings. There are fewer, taller buildings with the same number of units and the same number of residents. The difference here is that in Margulis, the clearance of the area was still in the future, whereas here, the area was cleared long ago to develop these projects. So it's not even arguably a plan within the meaning of the PHL. If the court adopts appellant's approach, a single city council member could effectively block needed replacement or even rehabilitation of NYCHA projects, thus leaving them to deteriorate until they can no longer be preserved, a recipe for the diminishment of the affordable housing stock in the city. This is precisely what the Margulis court cautioned against. And I will also note that the only court that has ruled on the multiple identical challenges in this issue so far was the Weaver 2 court, which did hold in denying a TRO that it was unlikely that the PHL Section 150 claim would succeed with respect to the redevelopment.
Thank you. Do you have,
My time up?
Do you have something? Yeah.
Well, I wanted to address the PHL Section 402B claims as well briefly, since, sorry, there's so many issues in this case. But PHL 402B does not prohibit the RAD Pact conversion of these, of the portion of these developments, the Chelsea houses, which was one of the previously non-federal projects that were federalized through that one-time opportunity the section was enacted to take advantage of, which was under the American Reinvestment and Recovery Act, which enabled the federalization of certain projects that had not previously received federal funding. The public housing law recognizes over and over again, including in 402B itself and Section 220, that it should be interpreted to maximize and not limit opportunities for federal funding and private involvement. And I think this claim really shows most clearly that the complaint in this action is really mainly directed at the federal policy divesting from Section 9 housing and investing in Section 8 project-based vouchers, which drives the need to undertake this RAD Pact conversion to fund the maintenance, and in this case, the replacement with new modern buildings of these projects. The appellant's argument would, if adopted, permanently foreclose conversion under RAD Pact, not only for the Chelsea houses, but also for all of the other Section 402P projects that have not already converted, which is about half of them. The PHL affords NYCHA broad powers for the purposes of maximizing both governmental and private financing opportunities. These include, under PHL Section 37, the power to convey interest in land and to demolish and construct buildings. PHL Section 220 also provides that that the PHL as a whole shall be construed liberally to effectuate its purposes, and, quote, consideration shall be given to its purpose and intent, among others, to empower an authority to do any and all things necessary to secure the financial aid of the federal or state government in the undertaking, planning, construction, maintenance, and operation of any project. And Section 220 has also implicitly modifies other PHL provisions to effectuate the legislature's public policy favoring participation of private enterprise in the provision and maintenance of low-income housing.
Counsel, we have your brief, so we have the information. Is there anything new?
I don't really have much new that's not in the brief because I don't think that much new was raised with the other argument today. So I'll leave it at that.
Thank you.
Thank you, Your Honor.
With regard to the statute of limitations, I'd just like to say that, well, first of all, our citation to the September 18th resolution, it fits within an exception for judicially noticeable documents. This court can and did take notice of it in our motion for interim relief, and I believe the law is pretty clear on that. It's in our brief.
Counsel, is it part of the record or not? Because your friend said it's not part of the record. Are you saying it is part of the record?
It's not in the record on the appeal from Judge Cohen's decision, but we would ask that this court take judicial notice of it.
It was considered by the trial court, though. It was considered by the trial court?
So what happened was, 4 days after the argument, we made a motion to submit it to the trial court. We brought it on by order to show cause. The trial court did not respond to that motion until after it had decided the underlying motion for a preliminary injunction. Then 2 days later, it said, "Oh, it's too late now. It's moot," basically. And then.
So then the issue that we're really dealing here with is whether or not that July 2025 order, if that's final or not, from which the statute of limitations runs.
Well, again, we contend, and apparently this court, at least on the motion for interim relief, seemed to agree that you could take judicial notice of the.
But what,
of the
What
September.
my colleague just asked was whether or not it was you didn't raise it before the lower court. You didn't raise it before the lower court. You became aware of it after that.
After the argument, we tried to raise it before
So
the
it wasn't addressed
decision.
below.
I'm sorry?
It was not addressed below.
It was not addressed below, that's correct. But we did try to introduce it into the record. Regardless, we did argue that the July 28th Rod/finding statement could not have triggered
So
the
what was the operative date that you argued before the court below that would start the accrual date of the 4-month statute of limitations? So what was the event? What did you argue below? That's when I'm having trouble. You're now telling me you didn't argue September 18th. Did you argue it was July 28th or some other document?
We brought this as a declaratory judgment action because honestly, I didn't see that there was any, it seemed to us that this was sort of creeping along towards a HUD
Can you
application.
please answer my question? Because what date is the operative date for the 4-month statute of limitations? I'm having trouble understanding what your date is. I really want to understand that.
We would contend that the operative date was the September 18th board resolution.
Thank you.
Thank you. Thank you very much. Thank you both.
Thank you, Your Honor.
Okay, you remain, and we have on Elliott Chelsea Houses resident versus Nisha.
May I begin?
Yes.
Good afternoon, Your Honors. I'd like to begin with the ultra-virus argument. We really look to Article 18 of the New York State Constitution, which sets forth the authority for the legislature for the provision of low-income housing. And for slum clearance, there's extensive case law that there are two distinct purposes. NYCHA is not arguing slum clearance in this case. It's arguing provision of low-income housing. Section 10 of Article 18 expressly says that nothing in the article grants authority to engage in private enterprise. And where I'm not sure if there's any, I was unable to find any authority in this division, but in the third department, they found, I'm so sorry, I'm so nervous, but the court found a similar lack of authority where the housing authority planned to sell housing to low-income seniors, even though
This
they
is
were.
the supplemental citation that was
Yes,
submitted,
Yes,
but it was a 1987 case that wasn't available to you earlier? I mean, because your adversary wouldn't have had the opportunity to respond to it.
We provided a letter of notice if the court finds the letter insufficient. We can live
You
with
made
that.
the argument below, you just didn't cite the case.
We made the argument below about Article 18, we just didn't cite this case. There's just case law interpreting the provision that was argued below. And with Article 18, basically is, public housing law flows from Article 18, and within the public housing law, which is NYCHA's organic statute, is where NYCHA's authority is laid out. NYCHA has extensive authority to provide low-income housing. Nothing in its authority allows it to demolish 4 existing public housing developments, concentrate, make them one development, move those tenants into a third of the public housing land, and use the remaining 2/3 or more than 2 city blocks in Manhattan to allow for the building of, I think it's 3,500 generally market rate, 2,400 market rate units, and 1,000 income restricted unit that are not that may be affordable to various income limits, but have not been represented as being for low income people. They may be for people making above 100% of AMI. Where the legislature has allowed for some commingling for the purpose of financing, it has provided specific protective provisions for public housing residents. And specifically for 402B, which only applies to the Chelsea development of the 4 developments we're talking about here, they provided requirements that the owner entity that is combined with a private interest to allow for financing would still have to be nonprofit, and NYCHA would have to have a controlling interest. Similarly, where the state established the Public Housing Preservation Trust, which allows for a combination of public financing through a NYCHA sister agency, the legislature established voting protections where the residents would be able to vote for it. The legislature has not anywhere authorized this kind of wholesale giveaway of half of our public housing land that's intended for low-income housing to be used for private market rate development for rents of $6,000, $8,000 that low-income people will never, ever be able to access. If I may shift to the public housing law and the ULURP claims. So I think one part is these are two similar but distinct processes. They have distinct requirements. So the key question is this a plan or a project? If it is either, both a Section 150 application is required and ULURP. It seems that these have been processed kind of parallel, concurrently by the agencies, but they're different forms that are discussed in the DOME project and also by David Burney, who's NYCHA's former chief architect and vice president of capital assets, something like that. That's in our record. This is definitely a plan. It cannot possibly be stated to be consistent with the 4 plans that had been approved in the 50s and the 60s for developments. It is not the thing that was approved. So it is either a new plan or it is a modification of those plans. And if it's a modification, Margolis comes in and tells us, is this a change to the essence of those approved plans? And it certainly is, because it combines 4 approvals into a single one, doubles the amount of housing, and devotes 2/3 of this public housing land to luxury housing, not for low-income people. I'll add, in addition to Margulis in Borek, there was similarly a modification that had been approved for a shift from 350 to 400 units. In Margulis, the change that was discussed as not a change to the essence was the number of units essentially remained the same, but the number of got reshuffled to a smaller number of taller buildings. And key to that is in the initial approvals, the legislature said a tentative number of units. There was an express authority to make some consistent modifications in the actual authorization for those plans. Similar for the city charter, ULURP is required where it is a plan or project, so it's the same trigger. That requires a public participation process that it goes before neutral third-party decision makers, elected officials. People are, both the tenants and the public as a whole is allowed to have an opportunity to say and express their opinions. These issues could have been raised in that process. ULURP is not the enemy. ULURP is democracy. There may be small changes that need to be made to ULURP, but at the end of the day, it is the law, and if NYCHA doesn't want to do ULURP, NYCHA should change the law.
So just to, thank you.
Thank you.
Do you mind addressing the article?
Well, first she has to make her.
I
appearance.
apologize.
It's a
I
different
thought she
case.
appeared before.
Elizabeth Nauer for the respondents. Thank you.
I'm sorry.
Okay.
Can you please address my earlier argument regarding Article 8 and more specifically whether or not this case precedent permitting the use of property belonging to NYCHA for mixed use, or as your friend said, luxury housing?
Yes, Your Honor. First, I'll just note that the argument that the redevelopment violates Section 10 of Article 18 was not made in either the petition or in any of the papers below, so it's appearing today for the first time. So there's no claim in the petition that Section 10 of Article 18 has been violated by the redevelopment. I will address that, though, however, in the few days that we've had to look into this after the notice of quote-unquote supplemental authority was submitted. The argument relating to Section 10 that I believe that they are making relates to—
Counsel, I don't want you to address that anything that is outside of the record, but within the record, there is argument made with regard to the different use of the existing NYCHA land. And part of it's going to be used for NYCHA projects, and another portion is going to be used for mixed-use properties. And I think, I don't want to speak for my colleague, but I think that's what the question was directed to, the fact that you are having luxury apartments on what 60 years ago was set out to remain, to be,
And yes,
you
and
know,
those.
not for luxury
Well,
apartments.
the purpose, NYCHA's purpose in undertaking the redevelopment is to enable it to replace this deteriorating housing that is very difficult to maintain. With
So you're doing this all over the city, and not every building, and I mean, all NYCHA buildings are built between 1940 and 1965. They're not all being demolished and rebuilt. Why this? Why these buildings? Why this location? Right, prime location, you know, on the Hudson practically, where everything is shiny and new right now. Why is this the location? Why aren't other NYCHA buildings being destroyed? Instead, they're being sort of refixed. People are being moved out, brought in, everything's being
For-
replaced shiny and new.
For now, and this also, this development, perhaps it is, although this really isn't a matter of challenge in this case, but perhaps it is because of the location that there's an opportunity to build market rate housing on what will become excess land in order to help finance.
But it's only becoming excess land because you're consolidating all of these buildings into these two large buildings. The land is still there, right? The NYCHA land, where all.
Right. And this will help facilitate the replacement of the buildings with.
But if you were replacing the buildings, you would be replacing all of the NYCHA buildings, not just two large buildings and then luxury apartments.
I think we're getting into a bit of a policy debate here as to what is the appropriate way of maintaining NYCHA
Well, let's not get into that, but let me just ask you, how many buildings are there right now?
I don't have that right in my head
And
right
how
now, but
tall are those buildings that exist right now, the NYCHA
there are
buildings?
mid-rise buildings. There's no dispute here that there will be a smaller number of taller buildings, which is exactly
So there'll
what-
be a smaller number of short
Of
buildings
of-
that exist as they are now, and then there will be a greater number of taller buildings?
There will be, the NYCHA housing units will be be replaced in phases to enable the fewest amount of people to have to.
I understand the
relocate twice.
phases.
So, but in essence, all of those units will be replaced
We
within taller
understand that as well. The question was, how many buildings are there now, and how many will replace the NYCHA buildings that are there just for the NYCHA residents?
I'm sorry that right in this moment, I don't have those numbers. Like, they are in the record, though, in terms of, I'm not quite understanding the
Can I
importance.
get back to my question? My real question,
Yes.
maybe I didn't say it accurately. What is your authority, whether it's Article 18, whatever?
Yes.
I know that they argued this below, and that's what I meant, and my
Right.
colleague said.
They
that as
argued
well.
below as that it was ultra-virus under the
Correct.
statutory authorization.
What is the authority to permit
Yes.
the mixed use, as your friend said, luxury housing on 2/3 of the area where the NYCHA buildings are presently?
And by the way, you may not think the question is important, but it's asked, so I'd like an
I'm
answer to
sorry,
it,
Your
and
Honor.
perhaps your colleague can find out where in the record it is.
Okay, thank you.
Because you're replacing it on 2/3 of the property, and it's interesting to know, and if it's in the record, then it is relevant, how many buildings there are now and how many will be replaced.
My colleague will find that information, Your Honor. I'm sorry, I apologize. To respond to your question about the statutory authority, the statutory authority is in PHL Section 37, which clearly allows NYCHA and any public housing authority to transfer interest in real property. I think that it also, PHL Section 37 must be interpreted in light of PHL Section 220, which I referred to in the prior case, which says that the PHL shall be liberally construed to effectuate its purposes. Here, the purpose of developing the market rate housing is both to increase the overall housing stock in the city, which is desperately needed. It includes also some additional affordable housing, but from NYCHA's perspective, it is to help finance the replacement of the older buildings, which have become very challenging to maintain, with new buildings to provide higher quality housing for the residents. I really apologize that I don't have the numbers of buildings right to hand, but
Thank you. Is that it?
well, I did want to point out that this is an appeal from a denial of a preliminary injunction.
We know what it is, counsel. Thank you very much.
Thank you, Your Honors. Just to address the question, there are currently 18 buildings across approximately 4 city blocks. The plan is to replace those 18 buildings with 6 replacement low-income buildings, and then 9 mostly market rate buildings.
So haven't they said that they were going to offer everybody that's in the buildings now a new apartment in the new buildings? How are they going to be able to do this if?
Yes, it would be, so the 18 buildings are getting demolished and consolidated into 6 new buildings that will be subsidized with project-based Section 8.
And they're going to have room for all the people that were in the 18 buildings to move into the 6 buildings?
The proposal states that it will. None of the documents are public. Everything is proprietary. These are things that would have been discussed in a ULURP, but they're generally, even through FOIL requests, we're unable to obtain any meaningful documents. So a lot of this is just not generally available. There are
Of the 18
representations, but we haven't
buildings.
seen anything binding.
You said 18 buildings. How tall are those buildings?
They are of different heights because they're on different developments. So for example, on Fulton, they're low rises on the avenues, and then mid-block they
And the 6
rise.
replacements will be how many stories?
I can give you the example for Chelsea Addition, I know, because that's the first one, it's phase 1. So there are concrete plans and financing that's been offered. The other plans, we don't know the
Is Chelsea
exact-
Addition the senior
It's the
housing?
senior building, yeah, so it's a standalone development for seniors only. And it's currently 14 stories. It's intended to be replaced with a 40-story building.
It's going from 14 stories to 40 stories.
I believe so. They're not my documents, not my buildings, so I'm doing my best to interpret what's out there. I'm sorry. And just to touch on the issue of interpretation, really the interpretation may be broad, but still must be consistent with the statutory purpose. And the statutory purpose, if they're not doing slum clearance, is the provision of low-income housing. Opposing counsel mentions the general increase or addition to housing in New York City. That is not NYCHA's mandate. NYCHA's mandate is low-income housing. And these 2/3 of the new buildings, the new space, the new housing are not going to be for low-income people.
And just to be clear, your argument is that the land that's there and the buildings that stand on it right now are NYCHA buildings, and that's what is authorized by statute.
It's authorized by statute and by the plans that have been approved by the city. So there were in the past, in the 50s and 60s, and I think Chelsea Addition was maybe, 68, so it's the newest one, 1968. And those are for low-income public housing. The plans are for low-income public housing. The plans don't mention any 2/3 of it being for market rate housing. And just to touch on Article 8, Article 18 was in our briefs. It was argued below. The case is what's new. And to go back on this question of a policy debate, really what's happening here is NYCHA is defending themselves with a policy argument that this is how they're going to finance it. But they don't have the authority to do this. If they had, one part of this is the Ultraviras, do they have the statutory authority to do it? The other part is they were required to get permission, and they completely ignored that. NYCHA probably wouldn't be here if they'd gone through ULURP. As David Burney attests affidavit, this is a big project. It should have gone through ULURP. It was required to go through ULURP, and had it would have been improved like the other projects that had. So in the Dome project specifically, for which we do have case law, and we have the NYCHA capital management person who was in charge during it, speaking to it in the affidavit, that specific project was improved. Democracy is not the enemy, neither is the legislation. If NYCHA wants this authority, it needs to go ask for it. It needs to go ask for a change of law.
Thank you.
Thank you.
Thank you both. Thank you all. White versus Vaccaro. Just hang on till we get settled a bit. Okay.
Good afternoon, members of the panel. I'm Peter M. Levine, counsel for the appellants. The question before the court today is whether a preliminary injunction against the defendant, in place now for 2.5 years, should be allowed to continue when the plaintiff's theory of liability has been properly rejected by the IAS court as a matter of law, and the plaintiff, to the extent he is entitled to a recovery, will attain full relief from an award of money damages. In other words,
Has there been any argument made that any monies have been dissipated or wasted or that wouldn't be available at a later point?
no, and there's zero evidence of that in the record. When I was last before Justice Crane on that point, by that point, we had made our motion to dissolve the injunction, to vacate the injunction. And I said, the remedy here is purely money damages. There's no irreparable harm. There's no basis for an injunction. The case law is clear. She said gratuitously, and I called her out on this on the record. She said gratuitously, well, if money's about to go out the door, an injunction is proper. I said, Your Honor, you have improperly imposed an attachment on Steve Vaccaro's funds. The plaintiffs have not made any showing whatsoever under CPLR Article 62 to justify an attachment. There is zero evidence, and the plaintiffs have never argued this, that Steve Vaccaro was even thinking of secreting assets, of engaging in fraudulent conveyances. He is following the ethical precepts. He's settling cases. The settlement amount is paid. He puts that settlement amount in his attorney escrow account. He files a closing statement with the Office of Court Administration. He delivers...
Before the case of In re Thelon, they had both agreed to do a 50-50 split
of
of
profits of the firm. But there's a two-step process here. First, there must be an allocation between what the law firm, the Vaccaro and White LLP, what the law firm's charging lien is, what's the value of the services rendered pre-dissolution, and then what's the value of the services rendered by the succeeding attorney, be he Adam White or be he Steve Vaccaro. So
Ultimately, is there going to be a hearing, I think that may be scheduled before Judge Crane to start to figure out
correct.
who gets what?
That has not happened yet. What has happened is we've had a trial on the merits, February 17 to 19, 2026. There was post-trial briefing. The post-trial briefs were submitted April 24th, 2026. We're still waiting for a decision from Justice Crane on a 3 discrete questions that she posed at the conclusion of the trial. Those have been briefed. But there is no scheduled inquest. We reasonably, from the very beginning of this case, we're expecting an inquest to follow the hearing on when did this law firm dissolve, because once you set that.
I thought that the judge had made a decision in a prior case that the dissolution date was March 16th, 2023?
That's correct. So to follow the chronology, there was TRO imposed November 8th, 2025. That's when the 50% escrow requirement kicked in, right at that moment. So this injunction has been in effect since November 8th, 2025.
Okay.
The preliminary injunction, the hearing on the preliminary injunction motion was scheduled for January 25th, 2024, but Adam White walked into the courtroom with documents he wanted to use as exhibits that he hadn't produced to me. So Justice Crane rightly said, well, we're not going to start today. We didn't have a hearing on the preliminary injunction until July 16th through 19th, 2024. We then got a decision in order December 2nd, 2025. Adam White files a notice of appeal. He then moves for re-argument. That motion is denied. He files a notice of appeal from that. He keeps those appeals pending for a year.
But they were
until
never perfected. We never heard
Correct.
those.
We're screaming, either perfect right away, because millions, over $1 million, now it's over $2 million of fees are restrained. We're saying, start the inquest. Do not wait for Adam White to perfect. Justice Crane is waiting. So in June 2025, we make a formal motion to dissolve the injunction. I write a letter on July 7th, 2025, saying, Judge, Adam White has yet to perfect. He's missed all deadlines. Let's have an inquest. Justice Crane sits on that letter, sits on that motion, does nothing. Now we have a conference.
I think the question has been answered.
Okay.
I think we'll hear from you.
We
on-
went through but
Thank you. We'll hear from you on rebuttal.
Good afternoon, Your Honors. Adam White, respondent. The question before Your Honors is the defendants never appealed the decision, the determination by Justice Crane of the preliminary injunction. They had an opportunity to file an appeal on that injunction. They never did. They've waived their right to contest the underlying preliminary injunction.
Well, doesn't CPLR 6314 provide that a defendant enjoined by a preliminary injunction may move at any time on notice to the other side to vacate or modify it? So is that not what he's doing now?
Absolutely. However, it is CPLR 6314 is not a vehicle to relitigate the underlying preliminary injunction, which is what they're doing in these papers.
But one of the reasons why, as my colleague pointed out to that particular section, is the failure to proceed expeditiously. And I think that that's what your adversary is saying, that you haven't proceeded in perfecting your appeals and things of that nature. And it's been.
If I may address that, Your Honor, the determinations of fact, Justice Crane made determinations of fact in the preliminary injunction. And I thought, okay, great, I can appeal those final determinations of fact, supposedly. And I hired Brian Isaac, a well-regarded appellate counsel.
We know him.
I would think so.
Been here before.
And so I sent this over to him. There were mistakes made, whatnot. Finally, he had without getting into all the details.
Don't. Yeah.
He said, we got a problem here. We don't have final determinations made. You can't appeal. They're not final determinations. And so there was a misunderstanding both by defense counsel and Justice Crane. And when Brian Isaac finally brought that to my attention, and I brought it to Justice Crane's attention, and he cited the case. There's a Donald Trump case that he recently argued, and he argued it and explained to the judge, Judge, we need to get a trial de novo. I can't appeal. We could have appealed it, but by not being final determinations of fact. So there was no deliberate delay on my part. The preliminary injunction determination was made by Justice Crane January of 2025. They had an opportunity to appeal that. They didn't. And again, a CPLR 6314 motion is not a vehicle to collaterally attack the underlying, what they're doing here.
I think part of his argument is that based on the Court of Appeals decision in Ray Thielen, which you talked about, I know Judge Crane didn't love the decision, but then again, it is a Court of Appeals decision, provides something different than your agreement provided in terms of the dividing of the fees.
Here's the problem, Judge. There is still no determination. There's a big dispute as opposed to whether In re Thielen applies in this case. We have maintained from the beginning that we had an agreement, a 50-50 agreement that would survive dissolution. And even though Judge Crane argued, we're not seeking to overturn Thielen, we're saying we had a contractual agreement. It was a 50-50 partnership for 10 years. We have documentation and there was testimony at the de novo trial that it was a 50-50 agreement, and all we're asking for is that the status quo be preserved. These are assets of the firm. 50% of these are assets of Vaccaro White. These are not Steve Vaccaro's assets. He collected 50% of firm assets. So these are identifiable assets of the firm that we're each equally obligated to hold.
Can I just ask one question just about In re Thielen and your particular argument that you all had an agreement 50-50? Does that fly in the face of the public policy of allowing the client to chart their own course? And how does that affect the fees?
Yes, In re Thielen applied to hourly fee cases only. There was dicta in re Thielen that discussed in the context of personal injury contingency fee cases. So our agreement, if the court ultimately finds that our agreement 50-50 survived, our position is it does not violate In re Thielen because the clients were free to walk and they still have to pay the same fee. The public policy in re Thielen was that it somehow, it compromised their abilities because then subsequent firms would not want to take over the case. Mr. Vaccaro took all of the cases, or clients went with him with his cases that he had been handling. They went with me with the cases that I had been handling. And there was no public policy there. There's actually a countervailing public policy. First of all, that partners should be able to contract around this and not to have this endless litigation. They should be able to contract around this. There's no public policy against it. And the countervailing public policy is to avoid situations like this, where on March 16th, Mr. Vaccaro or a partner claims, oh, the firm is dissolved. And on March 17th, all new cases that are coming into the firm's website and phone number, he's claiming 100% interest in the fees in, and he's scrambling and he's asserting that he's entitled to more of this. So all we're asking for, Judge, is that the status quo be maintained, the fees are identifiable. We're waiting for Justice Crane to make a determination.
We understand. I think we have.
Thank you, Judge. And it's also discretionary. There's no abuse of discretion by Judge Crane in maintaining the status quo. Thank you.
So,
I
Mr.
did-
Can I ask you a question? You, at the end of your brief, asked for alternative relief, that if we did not completely vacate the preliminary injunction, that we at least modify it.
Correct. In the brief, I write that Steve Vaccaro is holding $1.8 million. That number now is over $2 million because more cases have been settled. But let's just use the numbers in the brief.
Right.
Steve Vaccaro is holding $1.8 million.
So you talked about an offset.
Correct.
Right.
And Adam White is holding $750.
So what's your opinion?
He
on
is
that?
way over secured. And again, ultimately, at the end of the day, Adam White gets no more than a money judgment. There's no irreparable harm here. The argument you just heard about the status quo.
That's not the question.
Okay.
Address the question.
But in terms of an offset, there is, let's assume Adam White is totally correct in his view of the law, which he's not. Then if he is entitled, if the law firm is entitled to all the money that Steve Vaccaro is holding, it's entitled to all of it, then that 1.8 million goes to the law firm, which is then split 50-50 between Vaccaro and White.
So you're sort of taking 750 off of the
Take that
1.8.
off.
That's what you were doing.
Precisely. Justice Crane is punishing Steve Vaccaro for insisting on adherence to Thalen. She
So
said on
the
the
question was just to be clear. We just wanted to understand what your position on that was.
correct. No,
Okay.
that's my position.
Thank
on
you
it.
very much.
She is punishing Steve Vaccaro for standing on Thalen, insisting on an allocation. Oh, it's too complicated. It's too convoluted.
But
Why
the
don't
thing-
you just agree to 50?
And I asked a question in terms of something that your adversary raised in his briefs, but also just his final point, that the website was still operating and bringing in new clients. How does that get, just,
It does not at all. The Court of Appeals has made this very clear in Thalen. Cases do not belong to the law firm. Cases do not belong to the lawyers. Cases belong to the clients. Cases are not firm assets. Lawyers do not get paid for work they do not do. They do not get paid for work they do not perform. Unaffiliated attorneys do not share fees. And the mere fact that if someone's told, hey, call Steve Vaccaro, he's a great lawyer. So the client Googles Vaccaro and finds Vaccaro and White website. He calls, I'd like to speak to Steve Vaccaro. He retains Steve Vaccaro. Vaccaro and White has no interest in that case whatsoever. None whatsoever. And as one final point, as for the March 16th, 2023, that was litigated at the trial. The Justice Crane said on the record that no new evidence had been adduced to change that date. She was going to stick with that date, March 16th, 2023. You have no irreparable harm because we're talking money damages. There's no likelihood of success on the merits.
Thank you
Adam
very
White
much.
is arguing
Counsel?
that Thalen doesn't apply.
Counsel, thanks. Thanks very much. Thank you both. Rahman versus the City of New York.
May it please the court, Hannah St. Marie on behalf of the city appellants. This court should reverse. Petitioner did not meet his burden of establishing that he held a permanent appointment as assistant deputy warden. Rather, the evidence demonstrated that he only ever held a provisional appointment, and he failed to show that the revocation of that appointment was in bad faith or unlawful. First, petitioner claims that DOC acted arbitrarily and capriciously because it did not provide him with a hearing prior to revoking his appointment. And he claims that he was permanently appointed in September 2020, but that was a provisional appointment, as the record reflects. And I would direct
So
the
there was a provisional appointment for the warden, and there was a permanent appointment for position as a captain.
Yes, Your Honor, in 2017, he was
When
permanently.
he was demoted or taken off of the position of warden, was there, as a provisional employee, do you have a right to a hearing?
No, Your Honor.
As a permanent employee, do you have a right to a hearing?
If he was being demoted from his permanent position as captain, he would have the right to a hearing under Civil Service Law 75.
I'm going to use the wrong word, the complaints against him as warden, why were those complaints made to him as a provisional employee? Why were they given to him as a provisional employee? Was that because of he was a captain as a permanent employee, or something else?
Yes, Your Honor. The charges and specifications that were issued regarding his conduct while he was acting as an assistant deputy warden were issued because he had protections due his permanent status as captain, and the DOC could not take formal disciplinary action, things like demoting him from captain, issuing a fine, or docking vacation days, without following the procedures under Civil Service Law 75. But that protection does not automatically extend to the provisional appointment that he held as Assistant Deputy Warden, and that could be revoked without a hearing or any of those procedures.
I'd like you to address the discrimination issues.
Yes, Your Honor. DOT revoked this appointment because there were four separate instances of misconduct, each of which were serious, and the petitioner has never tried to explain. He makes no showing of discriminatory intent. He makes bald claims that the actions were done because of discriminatory animus, but this court has been clear that that is insufficient. And similarly, his claims about the alleged comparators do not suffice. He makes no showing that either comparator engaged in comparable misconduct, which was the reason for the position being revoked here. And similarly, I'll note that his allegations about the comparators don't extend to how they allegedly obtained their permanent appointments, whether they were in fact similarly situated to what he claims was a provisional appointment ripening into a permanent appointment. And it does not provide any further description of the misconduct that might allow them to be similarly situated to him. Unless the court has any further questions.
So I just want to confirm, as to the provisional appointment letter, it said provisional appointment, correct?
Yes, Your Honor.
And it didn't include any probationary period, correct?
No, Your Honor. That's on page 155 of the record.
Thank you.
Thank you.
Good afternoon, Sandra D. Parker for the respondent. The question is whether,
Counsel, can I ask you a question?
sure,
How did you establish that the petitioner and Santiago was similarly situated in all material respects in order to establish or suggest unequal treatment?
well, in terms of all material respect, I think the courts are clear that if you hold the same title or position, if you're subject to the same rules and regulations in terms of performance, that is sufficient. In this case, they both held the ADW, Assistant Deputy Warden title. They were both subject to the same rules and regulations as it relates to performance. They were both accused of engaging in misconduct.
Doesn't it matter
in
how
violating those rules?
I'm sorry to interrupt. Doesn't it matter how one obtains the position in the first place? So whether they attain it as a permanent employee or whether they attain it as a provisional employee, there's no indication whether, doesn't that make a difference in terms of being able to compare apples to apples, so to speak?
Oh, absolutely, Your Honor. I agree with that premise. But in this case, they all were appointed in the provisional position as the appellants described using that letter provisional appointment. In other words, Ralston, Santiago, and Rahman were appointed about the same time as ADW, and they held that position. The issue is there's nothing in the record that was offered by the appellant indicating that, in fact, Santiago, other than the procedure that she went through, which is similar, and just like the procedure that Rahman went through in terms of the appointment, was appointed permanently from a list, as they maintain must be done for her to obtain the permanent status. In fact, Your Honor, I submit that Justice Sweeting asked both parties to submit documents and information to support our respective positions. Rahman did. The city had an opportunity to do so. They did not. Instead, what we have on appeal is them making bare allegations and arguments disputing what was presented to Justice Sweeting when they had an opportunity to submit documents showing allegedly any permanent appointment that flowed from an appointment from the list. They did not. They didn't do so with regard to Ralston, and they didn't do so.
Ralston's demotion was rescinded, wasn't it? He was demoted, but it was rescinded, so
That's correct, but in the reason that Ralston, I think, is relevant, because Ralston received the same letter as Rahman. Ralston position ripened into a permanent status in the sense that
but how can he be compared when Ralston didn't have a demotion and and Rahman did?
Well, well, the comparison doesn't start with the fact that Rahman didn't have his demotion rescinded. The comparison is the different aspects of their positions and the rules to which they were exposed. And in fact, Judge Sweeting points out in the hearing that with regard to Ralston, he engaged in misconduct. DOC initially said, well, we're going to demote you, just as they demoted Rahman, but they rescinded it.
In Ralston, was there any evidence that he had been promoted off of a list as the provisional to permanent would require?
Absolutely not, Your Honor. It was the same set of circumstances as in the case of Rahman. He got that letter that had the quotation provisional appointment. He held the position for approximately a year. In fact, we submitted documents showing that he was referenced as.
So then your argument would be more so the discrimination as opposed to he should have been promoted or kept in that position. It was more so discrimination that he wasn't kept in that, right?
Well, it was discriminatory in the sense that you have comparators who were subject to differing treatment. Differing treatment in the case of Rahman because of his race, because of his
That
gender.
didn't come up below, though. That only was raised on appeal.
I'm sorry, that.
Apparently, that was only raised on appeal, I believe,
No, it was not,
below.
Your Honor. It was raised in our petition. We cited to the New York City human rights law and the New York State human rights law, arguing that he was Rahman was subject to discrimination based on his race, based on his physical impairment, and based on his gender. And we cited specific individuals who received more favorable treatment than he did in our petition. The city did not respond other than making general denials. Instead, what they focused on is the statutory language regarding provisionals not being converted to permanent status. But what
But also
Justice
provisionals can be terminated at any time without a hearing. I mean, that's part of it as well.
Absolutely, but in this case, what you have is DOC going to all of the trouble of bringing him up on charges, specifications, sending out notices, and they submitted in response to our petition arguing discrimination and the like, this reason, that is, you know, he did bad things, and so that's why we demoted them, and then they tried to take it away. No, that's not what happened. So Judge Sweeting looked at this and looked at the entire record and found, number one, that there wasn't a rational basis for the determination, and number two, that it was made in bad faith because of the discriminatory aspect.
I just will point out again that with regard to his race, it's raised in the appeals brief, but not in the record part of it. But anyway, thank you very much. Counsel, any rebuttal?
Quickly, Your Honor, I just want to respond to a couple of assertions that were made. First, Judge Sweeting did not address the discrimination claims at all, and in fact, the order is entirely brief and referring only to the arbitrary and capricious point. Second, DOC has never abandoned or changed its explanation for what happened here. It has the authority to terminate the provisional appointment for any reason under Civil Service Law 65, and it chose to do so in this instance because of these repeated instances of misconduct. I'll note as well that There were no comparators in the petition whatsoever. The evidence in Rolston is both incomplete. The court ended up dismissing that case as premature, made no factual findings, and the email that petitioner relies on saying that Rolston achieved tenure by ripening his provisional appointment is an incomplete part of an email chain that isn't even clear that it's referring to Rolston. Finally, I'll just note briefly that the Court of Appeals has been very clear that provisional appointments cannot ripen into permanent ones in City of Long Beach. And here we are only talking about the September 2020 appointment, which, as the letter on page 155 of the record shows, was a provisional appointment. Unless the court has any other further questions, thank you.
Thank you both. Of course. G Unit Books, Inc. versus Tompkins.
Good afternoon, Your Honors. May it please the court. My name is Josh Riesberg, representing the appellant, G Unit Books.
So, counsel, you're asking for a default judgment for a 4-month delay where it doesn't even appear that the defendant was served properly. Is that right?
I disagree, Your Honor, with your characterization.
Oh.
The central issue,
What aspect of that?
the fact
do you
that
disagree with?
the defendant was served properly. The lower court found that there was a prima facie showing of proper service, and the dispute below and the objection made by the defendant in this case is specifically directed to the sufficiency of service.
Which
address?
in the record, where was it shown that she was actually served at an address where she lived?
In the record, there were affidavits from the private investigator and the process server where 3 addresses were selected for service.
Yes, I'm familiar with the record. Where is it shown that
She actually lived there?
She lived there. What information was that based on?
People said, I don't know who she is. No, she doesn't live here. What evidence is there that she lived there, that it was proper, the address was proper?
An attorney affidavit was submitted in the lower court explaining that these addresses were selected from public databases. Justice Reed in the lower court, in resolving the issue in favor of the defendant, indicated that he did not believe that reliable indicators were shown, thus raising a factual dispute about the sufficiency of service.
So even if there is an affidavit from an attorney that said, or an investigator, or both maybe, that they had certain addresses, so then you have to go serve. At one of the addresses, somebody was there, he said, do you know this person? Doesn't live here, no, doesn't live here. And then there was another address, and your process server tried 4 times and then maybe left something there, but there was no indication that she ever received it. And I'm not sure you made any efforts to get to the 3rd address. So I'm trying to understand, how did you make a prima facie showing other than said, oh, these are the addresses? I could say that about anybody. I mean, you can't believe everything that's on the internet about all our addresses. So how did you make a prima facie showing?
The prima facie showing included the attorney affidavit. I'll acknowledge that there was no identification of the specific databases in the process server's affidavit, but the question here comes down to residence. And for purposes of CPLR 308, subsection 4, the question is not whether the defendant lived there or resided there.
No, I didn't ask you that question. Okay. What I asked you was, how could you ask for a default judgment for 4 months delay where it doesn't even appear that your client, the defendant, I'm sorry, not your client, but that the defendant was served properly? That's all I asked, was served properly. And you just said she wasn't. You essentially just said she wasn't in the answers you gave to the questions.
If that's how I came off in terms of my answer. I apologize. That was not my intention. The service of process issue is specifically in dispute, which is why in our papers, appellant argued that the necessary relief at the lower court level was to order a traverse hearing.
Was that requested
That was
at the lower court, or is that something that you're asking for now on appeal?
We're not asking for that. Well, yes, we are asking that on
Was it
appeal.
requested down at
It
the
was
lower
not
court?
specifically requested at the lower
Do you
court.
have to request that?
I don't believe so. I believe the law states that the lower court, if it did find a substantial issue of fact in dispute about the propriety of service, was required to order a traverse hearing. And I'll just point out that one of the cases that the defendant respondent relies on predominantly in its brief, I see my time is off, may I finish the answer? Is Federal National Mortgage Association v. David, where a reasonable excuse was identified because the defendant submitted a sworn affidavit attesting to non-residents. But in that case, the court ordered a traverse hearing. And the other cases at issue addressing residents in
Do we know if the parties requested a traverse hearing? Do we know that from that case?
I don't have that information off the top of my head.
Is there any prejudice to your client?
I would argue that in every case in which a defendant fails to appear, there's prejudice, but
That's not the case. So I'll just let you know that that's not the case. Read many decisions. I'm asking you specifically, your client, under these circumstances, was your client prejudiced?
there was no prejudice identified in the record.
Thank you. Thank you. You'll
Thank
get
you.
rebuttal.
Good afternoon, Your Honors, and may it please the court. My name is Kristen Gianaris for the defendant respondent, Ms. Shaniqua Tompkins.
Counsel, isn't it a fact that she has stated that she never received the summons and complaint?
That is true, Your Honor.
And the plaintiffs tried to serve the defendant at an address in Jamaica, but were informed by security staff that she no longer lived there.
Correct.
Then they went over a course of 4 days to an address, Green Avenue in Brooklyn, and a tenant there said, I don't know her.
Correct.
Is there any other address I missed that they went to that she was served at?
No, those are the only two addresses that were sought out by the plaintiff's counsel. And as Ms. Tompkins set forth very clearly and non-conclusorily in her sworn affidavit, she had not lived at either of those addresses. And with specific regard to the Green Avenue address in Brooklyn, she stated she had not lived there at the time of service, nor for 10 years prior.
Did she include anything in her affidavit to support that allegation?
She certainly did, Your Honor. Besides from unequivocally stating she didn't live there for 10 years, she did not receive mail there, but instead was receiving mail in a totally different county in Queens, which plaintiff's private investigator himself verified.
She got, there was some address at a post office box,
Correct.
right?
That's the Queens address I was
Queens
referring
address.
to. So plaintiff's counsel's investigator
Can't serve her
verified that.
there, right?
Correct.
Counsel, did
and
plaintiff ask for a traverse hearing?
I'm sorry?
Did they ask for a traverse hearing?
They did not, and their appellant's brief concedes that point, Your Honors.
But his position is that the court should have ordered one anyway. Do you have a response to that?
My response to that is the case law that we cite in our brief makes clear that a traverse hearing is only proper when there is a genuine factual dispute with regard to the validity of service. And here, the plaintiff's counsel has come forward with no evidence contradicting the defendant's sworn non-conclusory statement in her affidavit that she did not reside at this Green Avenue address.
And she had no obligation under the law, as far as you know, did she, to in defense or in her affidavit to state where she does live in order to oppose his request?
Absolutely. The Court of Appeals has held that a defendant does not have an affirmative duty to keep potential plaintiffs apprised of their whereabouts, and the law in this department specifically permits a defendant to rebut the presumption of proper service by submitting a sworn non-conclusory denial of service, which is precisely what Ms. Tompkins has come and done in this case.
Counsel, I have another question. I'm sorry to interrupt you. It's in my nature as a mother and a judge. They've never obtained a default judgment or a judgment at all, correct?
Correct.
So your client, does she have to offer a meritorious defense?
No, and the case law in this department is quite clear on that point, Your Honors. No showing of a potentially meritorious defense is necessary as a prerequisite to obtaining relief under CPLR 3012D, where no default judgment has been entered, and when there is no demonstrable prejudice, which the
Did they
plaintiffs
argue
here-
prejudice
No, they
below?
have never once articulated a single instance of how they are prejudiced. There is no substantive proceedings, there's no default judgment, there's been no discovery, and I think they conceded the point that they didn't raise prejudice here on their main argument. In sum, Your Honors, considering the state's public policy of adjudicating cases on the merits, the absence of any prejudice, the minimal delay, and defendant's assertion of potentially meritorious defenses, even though that is not a necessary element of this analysis, we respectfully submit that the motion court correctly allowed Ms. Tompkins to submit a late answer in this case.
Thank you.
Thank you.
Counsel?
Yes, very briefly, Your Honors. I will defer to the papers on the issue of meritorious defenses. And the only other item I'd like to bring up is with respect to the nature of the objection, which sounds solely an objection to proper service. An affidavit of service creates a presumption of proper service, which must be responded to with specific facts to rebut the statements in there. And here we have a statement that the defendant did not live at the service address for a number of years, since 2015. Notably, with respect to the other address, the Highland Avenue address, she said she had no connection whatsoever. That's an important distinction. The order indicates that the defendant said she had no connection to both locations, both the Highland Avenue address and the 334 Green address. That's not true, and it's also important. In the Cuomo versus Cuomo case that the respondent cites on page 29 and 30 of her brief, the excuse that the defendant provided was found to be reasonable. Service was improper because the defendant averred that she moved from the premises about 2 years prior and had no further contact. We don't have that averment here.
Counsel, doesn't our case law stand for the proposition that we like cases tried on the merits?
Yes, the public policy exists.
And there's no prejudice here. Why not go to trial?
The public policy does not supplant the rules. We're a system of rules, and the rules require that the defendant who fails to timely appear must come forward with a reasonable excuse.
Rules also require proper service.
I agree. I agree, 100%. And if the issue is in dispute about proper service, the lower court should have ordered a traverse hearing. Thank you.
Thank you both. Williams versus RXR Construction. We're starting with RXR Construction.
Yeah, it's me. Good.
You may begin.
Good afternoon, Your Honor. Sean Schatzel of Lewis Brisbois, appearing on behalf of RXR Construction and Development. There are various issues raised on the appeal, the appeals and the cross appeals.
So why don't we start? Okay, go ahead.
I would just want to say one thing at the outset. The primary issue is 240. Before I get there, I would just say, if Your Honors disagree with me on everything else, the counterclaims asserted against my client have been abandoned. No one opposed that portion of our
No
appeal.
appeals.
And the plaintiff's 241-6 cause of action, they only rely on one industrial code provision. So I would ask this court, if nothing else, dismiss all the other industrial code provisions. I think Your Honor had a question.
I was just going to ask you about the 240 here, where these windows that fall onto the person, onto the employee. Why is that not a 240 case?
Sure. So we have a few arguments there that I think should result in dismissal of that cause of action, or at least a question of fact. One of those arguments asks this court to overrule some of its prior precedent. If Your Honors decline to do that, I think we can win on other grounds as well.
So focus on the first department cases, not on the second, third, and other departments.
Sure. So first off, as to I'd like to discuss why we think we should overrule a certain line of decisions. But first, getting to, I think the best argument for us with this court's precedent and the Court of Appeals precedent is there's a long line of cases that when an object falls out of a worker's hand or coworker's hands, 240 is not implicated, and that is the.
This is not an object falling out of a coworker's home. These are windows, each one 9 feet, I believe, or 8 feet, weighing between 150 and 200 pounds. They're raised up on some 2x4s, at least 3 inches, maybe more, stacked in an angle against a wall, multiples.
Right.
And somebody's looking through them to inventory them. They're in storage, and they all tumble down and crush this person underneath all of the windows. So that, that kind of fall with that kind of weight seems to indicate a 240.
So I would refer this court to the Court of Appeals decision in Rodriguez, which is cited in our brief. In that case, plaintiff and one or two of his coworkers were carrying a 120-pound steel beam on their shoulders, and they lost their footing, lost their balance. It
But that's
collapsed.
not what we have here, right? I think that early, if you're going to talk about precedent, earlier this year, this court decided a case, Lucas, which is really on point with what's happening here, because it talks about object stack, the weight, the force, and when they fall over. We're not talking about people carrying beams and then they fall. There might be some kind of human involvement in that aspect, but this is particularly stacked objects that might have required securing.
So just to try to address the point about people's hands dropping things, what happened here, and this is conceded by the plaintiff in their brief, these fell over because the plaintiff and his supervisor were maneuvering them.
But that's what he had to do, to be able, you should be able to move them, but they didn't lift them to move them. They were simply lifting them one by one to sort of see, but there was nothing securing them. I mean, I can think of a couple of ways they might have been secured. I mean, ropes and this or whatever kinds of things. They mentioned that there were items that could have secured it, but there were none.
Right. So again, I think the maneuvering of the hands is significant here, and there's a ton of cases cited in our brief. But I would say to Your Honor, okay, if Your Honors disagree with me on that point, okay, there are a series of decisions. I think we're now getting to whether they should have been secured, which is the point Your Honor just
Secured,
made
yeah,
about
that's the
ropes.
240s of one.
And I don't think so, because the securing these windows by ropes at the time of the accident would have been illogical, wouldn't have made any sense.
Ropes or whatever it took to secure them.
Sure. Whether it's ropes or something else, anything securing them together wouldn't have made sense for the type of work they were doing at the time, because they had to move them to see the serial numbers.
Also, but they weigh over between 150 and 200 pounds, and their height was 96 inches. Why wouldn't you secure that?
I think that gets me to the argument about whether an object that is shorter than the plaintiff should trigger 240. But even if Your Honors disagree with me on that point, there are a series of decisions involving similar objects from this court. So O'Brien, cited in our brief, was a stack of windows that toppled over, and there were issues of fact as to whether they were required
Did they
to be
weigh
secured.
150 to 200 pounds and were the height of 96 inches?
Yes. In O'Brien, heavy windows. Cruz, very similar facts. 225 to 250 pound 4x10 glass windows, cited in our brief. And this court concluded that there were issues of fact as to whether a proper safety device required securing. Lopez.
Counsel, in this case, there was no, for example, a dolly or without wheels or however you can lock the wheels that had sides that went up on it, that went up the same height as the windows with a space so that you could have 2 or 3 windows or whatever the number of windows. Would have been very easy to lean the windows over. They would have had to have picked those windows up. Any one of the windows could have fallen. In this case, they were simply lifting them up to, not lifting them, shifting them slightly to see, and the whole thing, it didn't shift down, as we've seen in some cases. It totally went over the entire 8 feet or however tall they are. So, there are safety devices that could have been used. Here, there was none, and I understand that you want to suggest that, well, this was not the kind of thing that needed to be secured at all, but
I would say, Your Honor, even assuming that's the case, there could have been something to secure them. That is also the case in the Cruz decision, the O'Brien decision, the Kylan decision. all cases, some of which involve stacks of windows, and there's others involving boards and other sorts of things that are leaning against the wall, as here. And in all of those decisions, the plaintiff argued they should have been secured. This court found question of fact. In the Carrera case that we cite, the plaintiff specifically asserted that the objects in question should have had a hoist to lift them up, as opposed to requiring the parties to move them by hand. If I have 30 seconds, I'd like to briefly address the argument about potentially overruling. So there's a decision we cite from the Third Department, Oaks, and another one in Wright. And what the Third Department says is that when an object is the top height of the object, not the base, the top height of the object is shorter than the plaintiff, 240 does not apply. And we think that's supported by Blinsky, Runner, and importantly,
But I thought this was 96 inches tall. How big was the guy?
so the testimony in the record is the
I
plaintiff
think there's only one person I know that's 8 feet tall.
Your Honor,
He
He was on a basketball court last night.
to be clear,
San
just on the
Antonio
facts, this is
Spurs.
important. They were 8 feet wide, but they were 4 or 5 feet tall, and the plaintiff was 5'9". It is undisputed in the record that the top height of the windows were shorter than him. And I would ask this court to, I know my time is up, to take a look at the Mello decision. Mello versus Con Ed from the Court of Appeals from 1998, which this court has cited recently, and the Court of Appeals has cited subsequently, which that involved a steel plate, like a traffic plate you'd see in the road. They were using to cover a trench, and it was lifted vertically by like a hook, and it toppled over, fell on the plaintiff. The Court of Appeals said because it was.
Counsel, I have to interrupt. There are at least 5 cases where this First Department have come down stating that there's no de minimis height rule. Time and time again, we've rejected that argument. Isn't that the case?
And that's why we ask your Honor to overrule it, and we think the Mello decision from the Court of Appeals is squarely on point.
The Mello decision from the Second Department.
No, the 1998 from the Court of Appeals, Mello versus Con Ed.
And I just want to, you talked about the Crescent case, but in that case, there was a trailer, and the trailer is what was, they believe the trailer tilted because it was broken. So perhaps they were using what they thought was a safety device, a trailer, and that tilted, and they were due to broken wooden planks, and there was no additional securing. That's what caused the windows to fall over.
Which decision, Your Honor?
In the Crescent, you said O'Brien versus Crescent.
O'Brien, yes, that's
Did you
correct.
talk about O'Brien?
I did.
So I don't see that case is correct and as applicable here.
Even if
and you
Your
talked
Honor's-
about a case with boards. I think you meant sheetrock.
Sheetrock boards.
And that was a different kind of case. I was on that case, and that case slipped from the bottom. They were nowhere near the size that these windows were, or the weight. I mean, a piece of sheetrock just isn't that. And they slipped from the bottom. It was because there wasn't issues of fact whether somebody had bumped it and started it to go down. It's not what this is. It's not this. Anyway, you have some rebuttal time.
Fair enough, Your Honor.
Who's? I can't recall who you are, so you.
There's other appellants.
Yeah, there's another, yeah.
Good afternoon, Your Honors. My name is John Sandercock, and I represent the United Glass Systems. We will join in the arguments made by RXR Construction
Yeah.
as far as Labor Law 240. We think
Okay.
we think there are questions of fact on 240, and that Justice Moyne had it right the first time, but he erred on.
So do you join and adopt his arguments?
His
Okay, what about your other
My-
arguments
my
with regard to?
Other argument, it concerns our obtaining contractual indemnification from the National Wall Corporation. These United Glass Systems supplied the windows, but they were delivered, well, we arranged for the supply of the windows. They were delivered to the building by National Wall, and they were placed
we know
on
that. Yes, yes.
on boards, and if there was testimony that
What, you're claiming that you owe no contractual you have a contract.
we have a contract. No, we're claiming that they owe us contractual indemnification because they broke some of the windows as they were delivering them. And the fact that the
National-
windows were broken caused the plaintiff to slip.
National wall, but aren't, yes.
That's it. That's our argument. We moved for contractual indemnification, and Judge Moyne said there were issues of fact. We think we should have summary judgment. Thank you.
Thank you. Plaintiff.
Good afternoon. May it please the court. Vincent Chirico for the plaintiff respondent. What hasn't been discussed until this moment is the fact that there was a protocol in place on this site. And the protocol said that these windows, these stacks of windows, were required to be tied together in a particular way. Stack them on an edge, lean them against the wall, tie them with a rope. And this is RXR Construction's own testimony. Stacks were supposed to be tied together with rope. National Wall's witness says testifies very clearly that the rope, which should have been tied around the concrete or steel column and the windows, did not have to be untied in order to take inventory. So the classic, the largest argument that the appellants are making is, well, you didn't have to keep them tied in order, you couldn't keep them tied in order to take inventory because you had to look at the labels. Well, if you kept them tied, then the protocol required that they were kept tied. And if you didn't keep them tied, then you'd need some other mechanism. Here, what you have is plaintiff and his foreman working together with these 150 to 200 pound windows. And the plaintiff specifically says, I can't hold these like these. These are rocky, I can't hold them. And his foreman says, on page 246, 247 of the record, come on, I have to do it. Okay, so to appellant's point that we haven't identified a specific safety device that could have avoided the accident, well, suction cups. We don't have to identify a safety device, but suction cups, a forklift, any kind of mechanical hoisting device. This court's Villanueva case specifically holds that this kind of weight requires mechanical hoisting devices. There's no question about that. So here you have a wealth of First Department law, as this court has already noted. Most recently, the Carranza case from May 19th of this year, where
Do you want to discuss your 241-6 claim?
Yeah, I would only suggest that at very least there's an issue of fact with regard to the 241-6, because that industrial code section is not limited to the question whether these windows were properly stored, but also whether they were properly placed. And that's a Fontaine decision in this court. These windows were not properly placed on this platform, and at the very least there's a triable issue of fact as to whether the improper placement on these windows, to the extent that they were untied, that they were asked to be lifted manually, were properly placed or were not properly placed, and therefore a violation of Industrial Code 23-2.1A2.
Thank you.
Thank you.
Good afternoon, Your Honors. Nate Drexler for National Wall. As counsels have pointed out, National Wall did deliver and place the actual glass panes against the wall. However, that does not make National Wall negligent. The record establishes that they stored the windows in the exact manner that they were directed to.
Negligence is a question of fact. We can't decide whether they were negligent or not in the way, isn't that an issue of fact?
Well, I would say no. The record shows and demonstrates that not only did they place the windows in the exact manner that they were told to, but that there was no complaint, there was no other incident, and actually the windows sat there undisturbed and in that configuration for weeks.
What about United Glass's claim that some of those windows were broken when they were delivered by you? And I thought that part of the reason this whole situation happened with the plaintiff is they were taking inventory of the windows to see if there were some broken windows in that group. So how, isn't that an issue of fact at least?
Your Honor, I think on page 25 of our brief, we note that newest claim of negligence that National Wall failed to discover the broken window was raised for the first time on appeal. So this court should not even regard that argument.
Well, even if you didn't discover it, I mean, if it happened and they found it later, that could be negligence on your part.
Well, at the time, I understand the question, but I think that the important fact that these windows sat for 2 to 3 weeks in the custody, in an area designated by RXR, in the custody of United, and that National was no longer on the site, they weren't there the day of the accident, sort of negates that issue of fact. I think it may be an issue of fact for United Glass or for RXR.
Well, I mean, I think that's a good defense, but they may have other positions. They may say it's you. You'll say, well, you're never going to be able to prove it. But I'm thinking that at this point, with all the different claims and all the different parties, that there's at least an issue of fact.
Well, respectfully, Your Honor, I would say that even if there was some broken glass mixed in with these panes, that was in no way a cause of the accident. The cause is clear. The proximate cause was the plaintiff and his foreman or supervisor were leaning these glass panes away from the window, and at one point, plaintiff, I believe, moved from the side to the front where he was able to get crushed.
Yes, but to my colleague's point, they were moving the windows to try to find the broken window.
Taking inventory, you mean?
I thought they were looking for a window that was broken, and that's why he was going through each window, maybe?
If that's the case, it's still our position that National Wall had nothing to do with that. They left it there. It was there for 2 to 3 weeks, no complaints. No one called them and said, hey, these are the wrong way, or these may be broken. There was nothing to that effect. They were just in the custody of United and RXR.
Was it National Wall's obligation to somehow tie it after it placed it near the location?
It's a fair question. To that point, we would say even if, and there's been some discussion about this with Your Honors and also the other parties, but even if there were ties, which might have been more ideal, the nature of their work, which was moving these windows, these panes away from the wall, they would have had to have untied them or loosened them in some way, which again, that's the inciting moment. That's a superseding cause.
Isn't that an issue of fact? As my colleague just mentioned, that would contribute to the possibility of a negligence.
Respectfully, not the negligence of National Wall. Maybe perhaps the negligence of the others.
Thank you.
Wait, there's someone else.
Oh, sorry.
Not yet.
My name's Kevin Brennan. I represent the Super G Construction Company, which obtained summary judgment below, and there hasn't been any comment about it. So
You don't want us to do anything. We want you want
us to leave it alone.
So that's fine. Thank you.
To you.
Okay, just to briefly run through a series of points, if I can. I suppose I'll start with Super G. On that point, if Your Honors find that there's either these windows should have been tied and bound.
This is.
It's in our brief.
Counsel, okay. So we don't allow just standing, but I understand your point, and you had an opportunity to make your argument. You submitted a brief, and so he has an opportunity to respond to it.
So I would just say, if Your Honors find that these windows should have been tied and bound, or maybe that there's an issue of fact on that point, we see conditional contractual indemnity against National Wall because they were the entity that most likely stored those windows. We also
You're not alleging, are you alleging that Super G placed them there?
I was just going to say that. So we see conditional common law indemnity. There's no contract with Super G.
There's no
against Super G,
contracts.
right? And the reason we say that is because the record's not 100% clear as to whether National Wall or Super G
Saying
did
there's
this.
testimony from others that Super G did handle.
Exactly. That Super G.
Not just leave them outside, but bring them inside.
Exactly right. And National Wall, it was most likely National Wall, but there's testimony that Super G assisted, helped, and it's not clear as to which one. So
I think the record is on page 853, 854. I made note of it because there was a testimony that there was a possibility that Super G had unloaded some of them.
that's right. And I also point Your Honors to Casella's testimony at 646 to 71, where he talks about Super G maybe did it, and Ralph Iuli of National Wall at 772 and also 500. So the other points, very briefly, on the issue of hands, okay, and workers maneuvering things, carrying things, I'd say that, in Carrera, they were carrying a metal pipe. In Sahid, we mentioned in our brief, they lost control of a hoist counterweight. Rodriguez steel beam. Those objects, they only fell because the workers were moving them with their hands and lost control of them. That's what happened here. These glass windows were stationary. They only moved when the workers moved them and maneuvered and lost control of them. I'd also say, I think important for us, in the Cruz case, again, 4x10 window, 250 pounds each. There were issues of fact on securing devices. And we point to Kylan. This is 27 to 28 in our opening brief. That was a sheetrock board case, Your Honor, but there were 25 to 30 of them, and if you do the math as to how much each of them weighed, because there was a dispute between the parties on the weight, those boards weighed either as low as 400 pounds or as high as 2,100 pounds. If those boards, if there was an issue of fact as to those boards triggering the protections of 240 and securing devices, I think the same conclusion needs to be reached here. And
did those boards slip from the bottom?
They were leaning against the wall, similar to here, and my understanding from reading that case in the brief is that they toppled over like this, which is what happened here, except that the windows here were shorter than the plaintiff, and you heard our argument about that. The last thing I would say, Your Honors, is that ropes, suction cups, whatever devices are being thrown around here, they are not akin to ladders, scaffolds, pulleys, hoists, the safety devices that are set forth in the statute.
May I just ask one question? The case you just mentioned, you said, is Kylan?
It's a Kuylen, and that's discussed at length at 27 to 28 of our brief.
That's the case that involved sheetrock, not any.
No. That's the case that I was talking about. I was on that case. It didn't topple over. It slid from the bottom.
Then I'm sorry, Your Honor,
down.
I misspoke, but then we still have the Cruz case with 4x10 windows where it fell this way. So
Well,
there's a
good
lot of
thing
decisions
you
here.
still have that one.
Okay, thank you, Your Honor.
Thank you. Thank you all, I think, right? Yeah. Checking. Omapur versus 3M Properties. May begin.
Good afternoon, Your Honors. Glenn Lenahan with Oved and Oved on behalf of Appellant. Pursuant to this appeal, we are seeking the reversal of certain claims that were dismissed on summary judgment by the trial court because there are obvious questions of fact that the trial court overlooked.
So I would like to start with your fifth cause of action because in that action you claim fraud because the Mark, I'll call him Mark, submitted papers without the bottom sheet, without the signature sheet, or had a separate signature sheet and put it in. But your client indicated, Mernaz, indicated she didn't read them.
So, Your Honor,
and how do you claim fraud? How can you be defrauded when you yourself failed to read any of the documents?
So a couple things. As the trial court itself noted, and as the law, that you can rely on the description by your fiduciary of what is an agreement, and you are excused from reading it. And that is in the Shilpa Sacketh Realty Inc. v. Vidiyala case, First Department 2021. It says plaintiff was excused from reading the agreements because it relied on misrepresentations about the document by its fiduciaries.
But I thought that they had, I mean, I know that there was a fiduciary relationship here, but they had some problems in the past. So why did they have the right to rely, justifiably rely on, and hear her brother in this circumstance?
So, Your Honor, there were no problems until November of 2014, after these operating agreements had been executed, at which time Mark confessed to plaintiff, to the appellant, that he had been improperly taking money from the LLCs. He didn't say it was his reasonable compensation, which is what the fraudulently procured operating agreements supposedly entitled him to. The original operating agreements, all of them barred expressly barred Mark from receiving cash compensation from the companies. That was because he was gifted an outsized equity relevant to his sisters. He had 2 times their shares plus an additional 4%. And a 2015 memo written by his and Jacob Perunian, the father, the attorney, expressly laid this out. That says, Mark was given double share relative to his sisters to reflect that he and Jack were the primary principals of the business, locating properties, etc. The additional 4% being additional consideration for Mark being responsible for the day-to-day management, equivalent to a 4% management fee. Nonetheless, despite the fact that the original operating agreements barred Mark from receiving compensation, he was taking money hand over fist. At some point, he decided he wanted to document this, but he didn't actually want the members' consent. And he did this through 2 different law firms. The Seligson law firm, which drafted certain of the operating agreements, and Alan Winters, who drafted the other operating agreements. The Winters operating agreements were all executed at the same time on December 12th, 2012. In the days leading up to that, Mark told Appellant, come to the office, we're going to be signing documents to allow the trusts to come in for estate planning purposes. The members had set up trusts, and they were going to come in and obtain certain membership interests in these, what are called the family LLCs. So the trial court overlooked that testimony. Mark said the same thing. That's what he told them. Mark also testified he never discussed with his sister that he was taking money from the companies. He didn't feel he had to because she was gifted her shares. Mark obviously is ignoring the fact that Mark was gifted his shares by their father in the exact same way. So the trial court overlooked express testimony by both parties saying that Mark said, come sign these documents to allow the trusts in.
But let me just ask a question. Because I just want to bring it back to the issue of justifiable reliance. Is there some requirement that there needs to be a showing of united in interest?
Oh, sure, but they are united in interest here because Mark was the manager, our client, the appellant, was a minority member of the LLCs. She had no idea Mark was engaged in any wrongdoing because, as Mark testified, he never discussed business with her whatsoever. She was a passive minority member that had no rights, no voting rights, etc. She had no insight into the inner workings of these companies. So until Mark confessed in 2014, 2 years after the operating agreement started to be amended and signed, she had no idea that Mark was doing anything wrong. So there is a unity of interest. There's an express unity of interest because they were fiduciaries together Mark was her fiduciary in the exact same business. With respect to the Seligson law firms operating agreements, Mark brought those to the appellant and said, hey, the bank needs fresh signatures so we can get refinancing. Sign this, nothing's changed. And she testified to that over and over. This was done with 22 different documents over the years. She said, he came to me with a signature page, said nothing's changed, it's the same thing. I signed it because I trusted him. He was my brother, he's the manager, he's my fiduciary. She did not know, and Mark never told her, contrary to his representation that nothing changed, that actually now I'm giving myself the right to get reasonable compensation. And I'm giving myself super distribution rights beyond the other members. And I'm going to make my wife a member of one of the companies. And I'm going to limit the duty that I have to the companies and to the members. None of that was disclosed. She relied on the representations by her fiduciary that everything was the same and this was for financing. That's for the Seligson drafted operating agreements. As I said, with the Winters drafted operating agreements, that was the false pretense there was the come and sign estate planning documents. Now, some of those documents did allow the trust to come in, but the amended operating agreements did much more, including giving Mark compensation rights that he was never entitled to. And the trial court overlooked this and then dismissed her testimony regarding the coming to me with signature pages saying, sign this, nothing has changed, as self-serving. But he's not allowed to do that on summary judgment. And we've cited numerous cases, including First Department cases, saying that you can't, on a summary judgment, you cannot make that determination, and that a plaintiff's failure to recall specific details of deposition is insufficient to dismiss a claim on summary judgment. We're talking, there's no reasonable way that she would have been able to remember the 22 different occasions when at the time she had no reason to believe anything was wrong, and you can't differentiate one signature page from another signature page. You can't look at that and say, that was a 3M agreement, and that was United Fifth, and that was a different one. It's a signature page. She said exactly what Mark had told to her over and over. And it was the exact same thing that Jacob, their father, testified to at his deposition, that Mark did the same thing to him. So this is all on the record, and it creates, at a minimum, a question of fact as to whether or not these operating agreements were fraudulently procured. And the trial court completely ignored the fact of all the contemporaneous evidence that these were fraudulently procured. After they were signed, 2 years later, Mark instructs his staff, change management on the books and records to repairs. I don't want my father to see that I'm taking management. If he had legitimately obtained the signature of the other members on the operating agreements entitling him to compensation, why would he fraudulently cook the books to change the description of money that was paid so nobody would know? He also forged and had fraudulently notarized the appellant's signature on a consent document in 2012. And then in 2015, that memorandum drafted by the attorney that I spoke about earlier was put together, sent to Mark. We asked the attorney, did Mark ever email you back or call you or say anything that this is not correct, that your recitation of what my compensation is, being the outside equity grant that he got, was wrong? He said, no, Mark never said anything was wrong with it. Why is he getting a document from his attorney 2.5 years after these operating agreements were supposedly legitimately entered into, saying the exact opposite of what the operating agreements say regarding his compensation?
Thank you, counsel.
Thank you, Your Honors. May it please the court. William Sharon for the Harunian respondents. There was no reliance on a description by Mark, as my friend said, as the record shows.
Is there a dispute that Mark held a fiduciary role?
No dispute about that.
And so in holding that role, what's his duty to the other members?
Well, the fiduciary duty claims are part of the trial in 3 weeks. That was not dismissed. We actually didn't even make a motion for summary judgment against the fiduciary.
In terms of the reliance?
So on the reliance, Your Honor asked about a great question about doesn't there have to be a unity of interest? These are operating agreements where they're all parties to that contract. They're necessarily not united in interest. Moreover, it's uncontested in the record. It's admitted by Homoport in the record at page A5194 of the record. She had her husband review operating agreements in the past. He testified to that as well. There's no dispute about that. She just didn't on this occasion. She comes to this special...
Was he a lawyer, her husband?
No. Her son, though, is a real estate lawyer. Their son, who...
But he didn't review the document.
He did not review anything either. She didn't ask him to. She didn't ask her husband to on this occasion. They were all brought to this special signing ceremony, which was really unique. The two sisters are estranged and haven't spoken to each other for many years. Nevertheless, they're brought...
So just wanted to follow up on the point. The fact that they didn't review the documents, would that make the argument that something was changed speculative? Because how would they know?
So, yes, it would make it...
Except that he said it.
It would be entirely speculative, but actually this is part of the shift. There's been so many shifts by Homoport in this case. So the claim itself, the third amended complaint at page A1085 of the record, paragraph 118, for years, the fraud claim had been, you changed certain specific provisions after I signed. But then, at summary judgment, she was forced to admit, I have no evidence of any of that. And indeed, there's none. So at summary judgment, she changed the entire theory and said, you fraudulently induced me to sign all of them. I showed up, and by the way, she tells this court at page 2 of her reply brief that she was never given the full operating agreements and was only given signature pages. But at page A1031 of the record, which is her own affidavit, she admits there were 30 full documents that were opened to the signature pages. They were all there.
So is this a matter of credibility that maybe a trier of fact should determine, or how do we decide this as a matter of law?
It's only a dispute of credibility if there's a dispute between the parties. But in this case, as Justice Cohen correctly found, the only party disputing is Homoport with herself. Justice Cohen said at page A25 of the record, he points out that because the record was so uniformly against Homopore, she offers a new affidavit at summary judgment with new facts that my friend just talked about. First time, different from what she had testified to. And Justice Cohen calls that out and says all of these facts that she's now professing occurred, none of which she recalled at her deposition. I took her deposition. It's in the record. You can see pages and pages and pages where I ask her over and over, seriatim, who provided this to you to sign? I don't know. Did you ask any questions about what it was you were being asked to sign? I don't know. Do you remember what you were told? Nope. Again, did you ask any questions about what you were doing when you received the signature page? I did not.
So there is a cause of action I see that's still in, as you said, on breach of fiduciary duty, right?
Multiple, yes.
So-
Waste and the like.
So this cause of action that we've been talking about, the fifth cause of action, is actually for fraud and fraud in the inducement against Mark. And is that, I'm not sure if I'm positive how these all are different, but if Mark was definitely a fiduciary, did he have a higher responsibility when it comes to signing, her signing documents, about not to put something in front of her that says, sign this, it's all the same, and then it turns out not to be all the same? Isn't there at least an issue that needs to be tried here?
So first of all, there's no evidence that it's not all the same, as was pointed out.
Although there seems to be an allegation, I think I read that somewhere, or heard that.
Lots of allegations, 4 different pleadings in this case, shifted theories at the summary judgment stage.
Well, sometimes the plaintiffs, I did a lot of commercial stuff for a long time. I mean, sometimes the plaintiffs don't have all the answers at the beginning in the first complaint, and they amend it as they go through discovery. Clearly, this has been going on a long time.
Yeah, but this plaintiff didn't have any answers through a 2-day deposition, and she was asked repeatedly. And there are hundreds of pages of briefing at summary judgment. Justice Cohen held hours of oral argument. He delved very deeply into these very questions. He is intimately familiar with this record. And it wasn't just the pleading, it wasn't the first, the second, the third, or even the 4th pleading. At her deposition, she repeatedly said, I have no idea. I never asked any questions. And Justice Cohen rightly said, look, in New York, you don't get to have a fraud claim when you say, I didn't bother to read. I didn't bother to ask any questions. When, by the way, the record shows she had bothered to ask questions in the past of her husband. She'd asked her husband to read it for her. He's a business person. That's why he was in the same industry. That's why she asked him to read it. All of this, was drilled down by Justice Cohen meticulously. The fraud claim, which also I'll just say, it was an afterthought claim. This case was always breach of fiduciary duty. It wasn't until an amendment the following year that she added, I just remembered I was fraudulently induced. And again, the claim at that time was not that I was fraudulently induced to sign them at all. She agreed that the operating agreements were valid in all respects except specific provisions she was challenging.
Thank you, counsel.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the Court, Sophia Perna-Plank from Jaspin, Schlesinger, Narendran, counsel for defendant, respondent, orange and blue.
Good colors for today, I just have to say. I'm sorry. Although I know that the company doesn't exist anymore.
Thank you very much. Our brief goes into 3 different causes of action that are asserted against Orange and Blue, but I'm only going to address the aiding and abetting breach of fiduciary duty. I believe that the plaintiff appellant abandoned her claims for constructive trust and unjust enrichment, but we included them in the brief in an abundance of caution to the extent she was addressing them here on appeal. The plan is described in the record for deregulating rent-controlled and rent-stabilized apartments. Itself was designed by both Mark Harunian as manager of the family LLCs and his father Jacob, or sometimes referred to as Jack, to result in financial gains to the appellant and the family LLCs, not harm. You can't have a breach of a fiduciary duty or rather, no breach of a fiduciary duty can be inferred from conduct that economically benefited the family LLCs, which is exactly what happened here for years. There's no record evidence that any of the family LLCs have incurred any liability arising from Orange and Blue's work, and if anything, the family LLCs received a substantial financial benefit from Orange and Blue's work. Speculative exposure as advanced by the appellant is simply not enough. As a result, the aiding and abetting claim is non-justiciable. Hypothetical harm untethered to any imposed liability or proven diminution of family LLC value by Orange and Blue cannot defeat summary judgment. The claim that payment of Orange and Blue's legal fees in this action constituting damages is simply a red herring. Orange and Blue didn't cause any of the funds from the family LLCs to be used to pay for its legal defense. And again, there can't be any breach. No breach can flow from the acts that benefited the family LLCs. And simply here, Mark made the decision as manager of the family LLCs to fund the defense of an entity that did nothing other than create a benefit for the family LLCs. Appellant conflates Orange and Blue's awareness that Mark was the manager of the family LLCs with actual knowledge required for aiding and abetting. If anything, Orange and Blue knew the family LLCs were benefiting from the arrangement and were not in the least bit harmed. Knowing participation in a breach of fiduciary duty requires showing that the person provided substantial assistance, and this can't be established without actual knowledge. And there can be no actual knowledge of such a breach when the family LLCs were materially benefited and not harmed. I know there's a lot to address, so I can rest on my brief unless the court has any questions. Thank you.
Just to very quickly deal with Orange and Blue, to expose the family LLCs to untold liability, including treble damages, 9% interest and more, as some kind of benefit through criminal conduct it's an interesting take. The important thing that the court overlooked here is Orange and Blue received as compensation for its role in this fraudulent scheme against the government, the tenants, the lenders, $20,000. And in the large grand scheme of things, to Mark, that's probably nothing, having siphoned tens of millions of dollars, but it's actual damage. That's justiciable right there. The $175,000 in legal fees that they have paid, that the family LLCs have paid on behalf of Orange and Blue as more compensation without any agreement, without any common law right to indemnification, that's also damage. Moreover, this case is this court's decision in Newman v. Newman from 2022 expressly said the plaintiff's individual claims could proceed based on the allegations that he was exposed to personal criminal and civil liability as a result of the defendant's conduct. This court allowed those claims to go forward where there was only potential liability. That's the same thing that's going on here, and Orange and Blue should be brought back in as a defendant for their role. They knew Mark was the manager. He admitted at deposition, the owner of Orange and Blue, that he knew exactly what the scheme was, that none of this work was really being done, and he was giving his company, his letterhead, and that name, along with the checks going back and forth between the companies, as evidence that Mark could use with the government of New York.
So I wonder if I could take away from them and bring it back to the to Mark.
Yeah.
So two questions I have. First, how does really this fifth cause of action, this fraud, differ from the breach of fiduciary duty? Sure. And also, counsel said that your client wasn't able to answer a lot of questions at the deposition and that her claims have been shifting through each pleading. And I wonder if you could deal with those two issues.
Absolutely. So the breach of fiduciary duty is for the money that Mark improperly has taken from the companies to fund his lifestyle. $250,000 for his son's bar mitzvah, leasing a Ferrari, installing.
But that's all still in the case.
That's all still in the case. The fraud claim seeks to rescind the fraudulently amended operating agreements that gave Mark rights he wasn't entitled to, including the right to cash compensation that he did not have, the super distribution rights, the limitations on liability. So the fraud claim is to rescind those fraudulently procured operating agreements. With respect to deposition, plaintiff expressly testified at deposition with every operating agreement we had, Mark's absolute words that everything is the same. I just need your signature. It's just like before. Nothing has changed. The wording is the same. She went on to say, I had his, meaning Mark's, reassurance that nothing was different. There were many times that I was just given signature pages by Mark without anything attached to it. So she testified exactly at deposition what is in her affidavit, that she was told by Mark, we need these, nothing has changed, sign them.
What about what your opposing counsel said about every time there was a signature page with the whole document right beside it?
I'm sorry, what?
I'm sorry. He said every time there was a signature page with the entire document right beside it.
Well, that's not what she testified to. In fact, she says there were many times that I was just given signature pages to sign by Mark without anything attached to it. And even if the entire agreement was there, if Mark handed it to her, opened it to the signature page, and said everything is the same, she knew what the prior operating agreement said. She knew there was a bar on Mark receiving compensation. So by Mark saying everything's the same, he defrauded her. He has a fiduciary obligation under New York law of candor, of disclosure, of loyalty, and he didn't abide by any of that. This is why the law exists, that you can rely on your fiduciary's representation about what a document says when you sign it. This isn't the same as me contracting with a third party, a sophisticated business person at arm's length, where they've got a due diligence obligation. That's not this. This is completely different. The law treats fiduciary obligations seriously and differently. Here, there are questions of fact at a minimum about what happened. And the plaintiff outlined everything that she was told that led her to believe, oh, okay, he's telling me everything's the same. Or, oh, okay, we're signing estate planning documents. That's great. I want the trust to come in as members anyway. Without saying, and I'm giving myself all these rights that I'm not entitled to and that we never discussed. And he plainly testified, Mark, that he never discussed any of this with the plaintiff.
Thank you both. Thank you all.
Thank you.
Edward Roberts, LLC versus Shipman and Goodman.
Good afternoon, Your Honors. Howard Ellman for Appellant Shipman. Almost, but not quite, last but not least. Your Honors, this case boils down to a simple question. What are the consequences to a bad actor client whose own wrongful acts after the alleged negligence of a law firm caused all of its damages? The answer should be equally simple and equally clear. The law firm's potential liability is cut off by the superseding cause doctrine, and all of the consequences of the client's bad acts are theirs alone to bear.
So the malpractice, your client gave the information about the name, disinfects,
Correct.
which shouldn't have been given. Okay.
Well,
Then
well
they
Your
put-
Honor, I'm sorry, just to be clear, that we did not concede that. We just didn't move on that
Okay,
point.
so you don't move on that, but
Correct.
there was malpractice there. There's a question
There's a question.
as to
correct.
whether there's malpractice to that.
Absolutely.
Okay. Well, because of that, the government, the FDA, or whatever it was, put a hold on that.
Correct.
And so Walmart wasn't able to sell any of those products that said disinfects. It may be their fault because I believe the company, the plaintiffs, lied to Walmart or deceived them in some way
Correct.
by saying that disinfects wasn't merely a household cleaner, but really was a product that would disinfect. This is the time of COVID, so there was a shortage of all these products. Okay. What is your client's responsibility with regard to the resale of these products that are now being held because the government says, because they all say disinfects, you can't resell them? Who is responsible for that?
Okay.
Those lost profits.
Great question, Your Honor. And under Court of Appeals precedent, under Hain v. Jamieson, that responsibility is solely on ERL. And I'll unpack that for Your Honor. The way the superseding cause doctrine works is it presupposes that there was an original negligence that may have, in a vacuum, caused damages to a plaintiff. And in this case, had ERL not lied and deceived and cheated Walmart, maybe it would be a different case. But
What about the Hain case from the Court of Appeals?
Yeah, I'm gonna.
Okay.
Yeah,
we'll get to that.
I'll address that, Your Honor.
And how it applies here.
Yeah, sure. So the Hain case, there's one thing that we agree on with ERL, other than Nixon 5. But we agree that Hain v. Jameson sets the standard for the superseding cause doctrine. And what the Court of Appeals said in Hain is that the intervening act must be extraordinary under the circumstances or not foreseeable in the normal course of events or independent and far removed from the defendant's alleged original conduct. That's what happened here. It was entirely unforeseeable to Shipman that ERL would not just ignore its advice, but actually do the exact opposite of its advice and lie and cheat and misrepresent to Walmart repeatedly. And the record is rife with communication after communication after communication from ERL to Walmart, in which ERL affirmatively said, we have EPA approval, we can make kill claims, here's our EPA registration number. And Walmart's corporate representative, the only witness who testified on behalf of Walmart, was clear that the only reason they bought product at all
Yes,
from
it's
ERL.
because they felt deceived from Walmart.
Correct, because they were
Got that.
deceived. And the critical link, Your Honor, on the superseding cause issue is that ERL admitted at deposition that they only bought product from their factories when they had a purchase order in hand.
Because
So
they
going
thought
back,
it was, yeah, okay.
Going back to your original question, Your Honor, they're even assuming that Shipman was negligent for purposes of the summary judgment motion, as we did assume, even assuming that negligence, ERL would not have bought from their factory a single canister of wipes, but for their lies and their deceit of Walmart. So leaving aside,
How does what happened fit in that you apparently, the law firm, gave advice to the plaintiff, the client, that said, okay, you don't have the EPA approval yet, but while you're awaiting the approval, you can sort of go on a dual track and you can provide the wipes and don't say that they kill 99% of all the germs or anything like that. You can just say that they're multi-purpose wipes, which couldn't find too much of at the beginning of the pandemic either, and those were also important to sell. And you suggested that to them. If you hadn't suggested that, didn't that play into this whole mess here?
Your Honor, again, going back to Hain v. Jameson, I mean, what the Court of Appeals, of course, the superseding cause doctrine is not something that's granted or that's applied willy-nilly. In fact, Hain v. Jameson, the Court of Appeals referred to it as a rare case. And the rare case is one where the alleged tortfeasor, in this case, Shipman, the alleged wrongful act of Shipman may have given the opportunity for what came next, but it wasn't the cause of it. And in a hypothetical universe, if ERL sold the goods honestly and Walmart bought them, and again, hypothetical because Walmart was clear in their testimony, we would not have bought it, but for our understanding based on all of the misrepresentations that these were disinfecting wipes with EPA registration, in that hypothetical universe, then yeah, that might very well have been on Shipman because they gave that original advice. It was an EPA embargo and there were goods that were stuck. But the whole point of the intervening or superseding cause doctrine is that it breaks the causal chain. There may
I
have
wonder
been
if we can look, I mean, when you talk about the Hain case and you say there was a cow, it wasn't the initial, I mean, it wasn't the ultimate cause of this woman's death. It was the car that ran her over. But the court said it was the cow on the road that she got out and moved. So the question is, was it not the misidentification of this, I'm just asking, the name disinfects that led to the embargo and then and before that, of course, led to them going one step further to mislead the company.
Well, let me. I think there's two questions there. One is nothing Shipman did or said at all led ERL to lie to Walmart. Like, period, full stop. There is no evidence in the record at all that Shipman gave any advice like that. But the bigger question, Your Honor, and it's a really good question, and I think this is like a super intellectual, like deep question, But if you look at it in that context, there never would have been a single canister for the EPA to embargo. Assume the bad advice in the beginning, right? Assume that bad advice. But for ERLs, lies and misrepresentations, they wouldn't have sold anything to Walmart. And if they wouldn't have sold anything, then there wouldn't be one canister for the EPA to embargo. There would be not $1 of out-of-pocket expenses. There would be none of that. And that's exactly what the superseding cause doctrine is supposed to remedy when there was an initial alleged, I know I'm out of time.
There's a question.
Sure.
Counsel, but you could have told your client, wait for the EPA number in January.
Your Honor, sorry, I thought you were done.
So they argue that the embargo was triggered by the name and by the failure to obtain the registration before selling it. They applied in November. They should have gotten it in January. And the advice was you can go down this dual language track, which is the same thing that PJ said. Isn't there issues of fact on that?
Absolutely not, Your Honor, because there's no question.
Had they not done the dual, will we be here?
Well, Your Honor, I mean, the causation is a tricky thing because you could say, had the three principals' mothers not given birth to them, 40 plus years ago, we wouldn't be here either. But something has to be a substantial cause, and then the superseding cause doctrine fills the gap when the defendant engages in wrongful conduct. So again, and this is on all fours with the law in Hain. Hain is distinguishable because that cow got out and it was entirely foreseeable that if a cow gets out, it may get onto the road and there may be a car accident. That is way different than what happened here, which is that the law firm gave advice to the client, says you can't call it a disinfectant, you can't make kill claims, you can't use anybody else's EPA number, you can't do any of those things. They do all of those things, and Walmart consistently testified, we wouldn't have bought anything had they not done that. And
Thank you.
Yeah, I'm out of time.
You have rebuttal.
Good afternoon. Good afternoon. May it please the court. Andrew Bluestone for plaintiff, respondent, appellant. There is no negligence. I mean, it's not disputed that there was negligence here. And it's not disputed that defendant solely sought summary judgment on causation. And causation, as my brethren says, is a tricky thing, and it's a fact issue. And the facts here are really in dispute. To begin with, under Haynes, a superseding cause must be extraordinary under the circumstances and unforeseeable in the normal course of events. It was entirely foreseeable that given the advice on the dual track process and having the responses to Walmart scripted by Shipman, they would have gotten into the problem with the
So
EPA.
when you say, well, first of all, the dual track was that you can go ahead and use Disinfects X
Yes.
as a household cleaner.
Yes.
Until you get the FDA approval.
And afterwards, too, as a household cleaner, but yes.
Until you get the FDA approval. When you get the FDA approval, then you can use it as a disinfectant after that.
Or to get the house brand for Walmart.
Or it can be used as a disinfectant house brand, but you have to
With
get
a new
the
label, Your Honor.
FDA approval.
With a new
first.
label that is compliant with the EPA.
Okay, but you must get the FDA approval first.
If
So
you're going to call it a
before-
disinfectant, yes.
Before your client gets the FDA approval, your client tells Walmart, you can use this as a disinfectant.
I don't think they actually say that. And that's the
Because
problem
that,
here.
I think, is what Walmart said, that they would not have purchased this product if they knew that it was a disinfectant, if they were not told that it was a disinfectant, because that's all they wanted. They didn't want any household product.
I'm going to disagree with that, Your Honor, because Ms. Ashoff, who was a sole witness for Walmart, contradicted herself. And I'll direct your attention to the 1389 and 1397 in the record. She said we needed wipes. We wanted wipes from these guys. We wanted to fill our shelves. They had 3 million canisters of wipes in their 4,000 stores on the shelves. They were selling 500,000 canisters a week at the height of the pandemic, every one of which said, this is not a disinfecting product.
There was an item fact sheet that was submitted to Walmart.
Are you talking about Works? Works, okay, so let me explain. Works is a proprietary program that Walmart requires sellers to use to list the characteristics of the product they're selling to Walmart.
Right, and that particular fact sheet, I mean, it's at the Joint Appendix 440, asked whether or not this was a disinfectant, and then was it a disinfectant item registered with EPA Works, and both answers were yes.
No, I think we're talking about the custom brokers filing which led to the embargo. The Works application itself said this is not a disinfectant. And there's no question that Walmart knew that it was not a disinfectant. They were selling 500,000 canisters of this a week, every one of which said this is not a disinfectant. They were being pitched on being the house brand, the quality QV, once they got the registration number. And there was some discussion about what the registration number would be, and that they used Lonza, and that Lonza had a registration number. But there's only a question of fact as to whether or not Walmart was under the impression that it was a
Ashcroft
disinfectant.
emailed on October 20th and says, to verify, you are EPA registered in all 50 states.
Yes.
Matthew Deck responds, yes, our product is approved for distribution in all 50 states.
They were talking about whether the Lonza product that was going into the...
Counsel,
Yes.
did they have an EPA registration at the time she asked
No,
in this
Lonza
email?
did. And they thought they could use the Lonza number because they were buying the Lonza.
But that's not what they put in their response to Ashcroft. They said,
understand.
yes, we're registered.
But even after that email, they bought 4 million more wipes. They were not deceived because they knew they needed
They
wipes to
bought
get them off the
400
shelf.
million more wipes because Matthew Dweck said, yes, our product is approved for distribution in all 50 states. He didn't say Lonzo is approved for distribution in all 50 states.
I understand what you're saying, and I
Okay.
understand the question, but the subsequent conduct of Walmart was to buy more and more wipes, even as the ERL was telling them we cannot make kill claims until January when we expect to get our registration number. They were very clear that no kill claims could be made, no kill claims were made, and Walmart, which is the largest retailer in the world, was selling 500,000 canisters a week. They knew exactly what they were selling, and they were happy to sell it. And Ashoff, who at 1389 and 1397 contradicts herself on that issue, makes the deal.
Thank you.
Your Honors, I need to address a few things that my friend just said that are just utterly false and not supported by the record. First of all, my colleague said that Shipman scripted ERL's communications with Walmart. False. There is not one thing in the record where Shipman gave any advice at all as to what ERL should tell Walmart. The item fact sheet that Your Honor was referring to, that item said, it says yes, regarding being a disinfectant and registered with the EPA and Works.
And that's something that was submitted to Walmart.
That is something that was submitted to Walmart. An email dated 10/29/20. This is Joint Appendix 456. Both formulations are EPA approved.
Counsel, didn't Lonzo tell Ashcroft that they weren't EPA registered?
Well, that's exactly right, Your Honor, and that's when the jig was up. Lonza tells Walmart, hey, these guys are using our number and they don't have any authority to do so. And Walmart goes, wait a second. You've told us all along you had EPA registration, you
In
had a
all
FIFRA
50
number,
states.
all 50 states. And by the way, to Mr. Bluestone's point about the goods being on the shelves, Ms. Ashoff testified, and there's also emails to this effect, that when the goods came in with the multi-purpose label, she said, where's the disinfecting label? And they said, well, there wasn't enough time in this early shipment. And then this is super important, Joint Appendix 451. Ms. Ashoff says, but the point is you can make kill claims, correct? So we can put this on Walmart.com and we can make signage. And these guys don't say, oh no, we're waiting for it. They say, yes, you could put it on your website. They actually gave Walmart the verbiage to put on about kills 99.9% of product. They lied to Walmart. They deceived Walmart. And you know what? Walmart's a big company, but it's run by human beings, and human beings get deceived. Kristen Ashoff was the representative who was dealing with ERL. She was told time and time again that this product is EPA registered, and here's our FIFRA number, and here are all the kill claims you can make. And she only ordered the goods because of those misrepresentations, and they stopped ordering and canceled the orders when they found out it was all a bunch of lies. And based on that, again, going back to some of your Honor's questions earlier, there wouldn't have been one canister. So even if Shipman was negligent, superseding cause assumes that there was a prior act that was negligent and that could have caused. But that act would have led to nothing.
What was the act of negligence? What was Shipman's act of negligence?
The alleged malpractice in advising them that you could use the word disinfects. Had ERL followed Shipman's advice and didn't lie, cheat, and steal its way to tens of millions of dollars in orders, then it would have been no harm, no foul, because there would have been no product, no EPA embargo, no out-of-pocket expenses, no potential lost profits, period. And that's exactly what the superseding cause doctrine is designed for.
So didn't the court, after the lengthy oral argument, say that certain damages were still in and others were out? I mean, she kind of split it a little bit.
She did, and she was really, I don't know if Your Honor read the transcript, she really was wrestling with it.
Yeah,
because I fully get that it's a tough question, but there's no splitting the baby on superseding cause. It's either a superseding cause or it isn't. And if it is, that just cuts off liability, like period. So what the lower court, what Judge Schechter was wrestling with is, well, there are these goods that are now there that you can't resell, which I fully understood, and we had a lengthy conversation about that. But my point there and my point here, again, is that you don't have one canister to sell if those guys didn't lie, cheat, and steal their way to their sales.
Thank you.
Thank you.
So as to Shipman not scripting the customer's responses, I asked the court to look at Joint Appendix 1554 to 1558, and Joint Appendix 1504, and Joint Appendix 266 to 70. Examples of Shipman scripting responses to the clients. The Shipman advice on the brand name, the labeling, and the right to legally do a dual track led the clients to make their first purchases.
I just want to revisit the issue of the item fact sheet, because now your adversary has confirmed what I asked earlier on about the item fact sheet that was submitted to Walmart that asked, is this a disinfectant? Answer, yes. Is this a disinfectant, EPA and something else? The answer, again, yes. Was that filled out by your client or someone else?
The fact sheet was produced by the client, but it was for the sale of the disinfecting product in the future. They were pitching the disinfecting product in the future at the same time the dual-track multi-purpose wipes were being pitched. And there's confusion and overlap between the communications concerning the great value stuff to come in the future after registration numbers and the current multi-purpose wipes now. And they were going back and forth, and there was bleeding between the two things going on at the same time. That's why they talk about the Chinese New Year. That's why they talk about we can do it after January. That's why they talk about we can do it in the near future. That's why they talk about we can't do it in this shipment because the next shipment would be after Chinese New Year.
Was counsel correct when I asked that question about Judge Schechter's decision, that once there is an intervening cause, it's either all or nothing, that she was trying to split the baby, say, well, there might be some damages that you are entitled to, not all of it. Was he right that that's not an accurate statement of the law with superseding cause?
It's not an accurate statement of the law in that the facts don't fit the Hain case, that there was a unreasonable, that it was extraordinary under the circumstances and it was unforeseeable. It was not extraordinary under the circumstances that given this advice, the EPA would embargo all of the material in the United States, causing a $30 million loss.
That was not unusual? Or?
It was not unreasonable, not unforeseeable. Of course not. The EPA embargoed the product solely on labeling. They didn't know anything about communications with Walmart. They didn't know anything about anything except the fact that the label looked like a disinfecting label, had warning signs, had the disinfect's name, had the wrong font, had images of places you could use it, which implied that it was a disinfecting product. And you can find that all at page 1600 to 1610 of the record. And the coincidence here, which hasn't come up before the court at all, is that on January 19th, the EPA sent a note to ERA asking about the shipment. On January 26th, 2021, that's at 768 of the record. On January 26th, 2021, Works sent a notice saying, you have a problem with your label, we're kicking you out of Works. Once Works kicked them out, Walmart couldn't sell their product anymore because Walmart depended upon Works and relied upon Works to verify good product to sell.
Thank you.
Very next day, Your Honor, EPA embargoed everything that existed.
Thank you.
They were all related.
Thank you. Thank you both. Vargas versus 250 West 43rd.
Yeah.
You're IG, aren't you?
No, Your Honor, I have the Park defendants.
They're looking for which ones. Okay, go ahead.
Good
Park.
afternoon. My name is Nate Drexler on behalf of the Park defendants, Park Premium Enterprise and Park Developers and Builders. Your Honors, a very straightforward and simple argument from me today. The documentary and testimonial record establishes that it was ING, not Park, who was the general contractor for the accident area. Of course, it's undisputed, a couple undisputed facts, that plaintiff was employed by EN. EN was retained by ING. There were permits that were pulled by both GCs. My clients, the Park clients, the Park defendants, had DOB permits for the 3rd through 13th floors of this hotel renovation. ING, conversely, had the permits, the DOB permits for the 1st floor, specifically the bathroom where the work was being performed. It was a concrete job. So ING retained EN to perform demolition of this floor. This is where the accident happened. This was also confirmed by the plaintiff himself, who said he saw ING, he observed them, he saw their people around. And then when asked about the Park defendants, he said, I've never even heard of them. Well, this makes sense because Park was only ever on the 3rd floor and above and had nothing to do with the work that was being performed on the 1st floor and below. We would also note that the agreements make this arrangement clear. The agreement between 250 West and Park contains no designation of Park as the GC for the whole project. That is sort of the line that's being spun now, is that it may be vague as to whether the Park GC was actually ahead of the whole entire construction project.
Well, that does seem to be what some of the people are testifying to. I mean, I must admit it was pretty confusing to read all the depositions, and not everybody knew who anybody was, and they assumed people were people who they weren't, and there was no contract, I think, between Park and ING, right? ING was had a contract with the owners, but not with Park.
Correct. And I agree. To your point, there was some confusing testimony, but the most clear testimony came from, well, first, Park, who their supervisor said that they were hired to perform work only on the third floor.
Well, that's what yeah, but not everybody else said that. I mean, you think that's the best because that's good for you, but I'm not sure everybody else agreed with you.
Was there testimony from Sirkin
Yes, there was.
that might have indicated that Park was the GC or construction manager?
Yes, forgive me just for 1 second. Yes, Sirkin's testimony that the Park defendants were in charge of the construction site. This also goes to another point, which describes this very general project-wide coordinations that this court has consistently held insufficient to impose statutory agency. The legal standard under Russin is work-specific, not project-wide. So even assuming arguendo that these conclusory statements from the Sirkin testimony are true, it still doesn't establish liability. It's far too general. And there's other testimony, even from ING's own owner.
Does it establish a question of fact?
Respectfully, not with the other testimony, because while there's confusing testimony, ING's owner, principal, admitted under oath that ING was, quote, the general contractor for the area where plaintiff injured himself. There was also testimony from Ron from ING that we were hired to do concrete restoration work and bathroom work. And he testified that ING retained EN. He also testified.
So we should consider those, but not the other one that says something different?
The Sirkin testimony doesn't actually say something different. It just sort of broadens his particular opinion as to what the Park GC's responsibilities were, but that's not reflected anywhere in the record, especially with the most objective.
Except that it says that he oversaw the demolition aspects of the project, and that was directly related to demolition, the work that was being done by the plaintiff.
It's still in direct contradiction to ING's principle and to the testimony of Ron and to the testimony of plaintiff and to the most objective evidence, which is the DOB permits.
Which is a question of fact then, right? There might be three on one side and one on the other, but it's still different.
Sure, but respectfully, even if it's an issue of fact, we have a work-specific, not project-wide standard, and there's no evidence whatsoever that the Park GCs oversaw the work of the demolition or instructed or had any kind of stop work capacity down in that part of the renovation project.
Does it matter that it's not an issue of supervisory or control? There might be an issue of notice. Does that matter?
Well, we argue that this is a means and methods case rather than a dangerous condition case in the first place. So the critical question.
This was a floor collapse?
Was a floor collapse, that's correct.
What means and methods as opposed to?
He was using a hammer to hammer the concrete. There was specific instruction on how to perform his work as a demolition. And at any well, I'll rest on my brief if you don't have any other questions.
Good afternoon, Your Honors, and may it please the court, Samantha Velez for ING Group. So ING's appeal really rests on 2 points: that plaintiff did not establish entitlement to Labor Law 241, and that 200, in the motion court's decision, they incorrectly permitted the claim to proceed on a dangerous condition theory of liability, and we agree that it's a means and methods case. Starting on the 241 point, we argued in our brief that we are not a statutory agent or we're not a proper labor law defendant because we didn't exercise the requisite supervision, control, and direction over plaintiff's work. And none of the governing contracts defined our ING as.
ING is the company that hired Modern, who was the employer of the plaintiff, right?
Correct.
So you're saying you have no supervisory control, nothing over potentially from all this testimony involving the plaintiff?
So our argument is that plaintiff was acting outside of the scope of the work in the contracts because the contract between 250 West and ING does not, it only allows for non-structural work.
Didn't Ron testify that he hired work included removal of existing concrete slab on the first floor?
So Ron's testimony certainly raises triable issues of fact, which is our argument on 240, but it should be noted that Ron he testified that he wasn't involved in the project. So Isaac, his father and the principal of ING, his testimony is probably more instructive since he was, involved in the project.
And I thought that Augusto was the project manager, and he was employed somehow also by your company, and there was testimony that he was able to raise safety issues with Modern, plaintiff's employer, and act as a supervisor. So I think there's a lot of questions here about
Yes,
controlling
Omar, he managed more, or Mr. De Augusto, he was doing the coordination, making sure that Modern was progressing, but didn't have stop work authority. He was kind of a point of communication, but not per se, or not.
If you're supervising the trades, I mean, it's kind of GC type of work. I don't see how there's not some issue of fact as to your position here.
Our position really is that there are issues of fact, and also briefly, there are material issues of fact as to how the accident even occurred. Their plaintiff in his workers' compensation C3 form said that he tripped over debris and fell. Then,
So the whole floor fell, right?
So the demolition work, or he was using the chipping hammer on about a remaining portion of flooring, but 70% of that first floor was already removed. So this was a remaining piece, about 4 to 5 feet, the purpose was to destroy the piece he was standing on.
But he fell 25 feet because the floor that he was standing on fell, and then to boot, he testifies that he was tied off, but that the rope broke, and so the whatever he was wearing to try to protect him didn't work either. Sounds like that's how the accident happened.
Yeah, there's multiple versions of this accident. Oh, thank you. I'll reserve any other comments on our rebuttal.
May it please the court. Good afternoon. I'm Christina Mercado with Block, O'Toole, and Murphy for the plaintiff respondent. First,
He put on the harness. He tied himself to the string.
that's correct. And then the rope broke. It's a classic 240 device.
So
that
he
broke.
was
There's
employed
really
by, he was employed by EN.
Correct.
They were hired by
ING.
ING.
That's correct.
Okay. And ING had control over that workplace because they were responsible. They were the ones hired to do the demolition.
That's correct.
All right.
They do have a permit on page 2057 of the record to remove existing concrete slab. That's ING from August to October of 2018.
And ING was hired by the owner?
That's correct.
How does Park play into this?
The first thing I want to mention with Park is that it doesn't have to be one or the other. There are plenty of construction sites where there's one overall general contractor responsible for the entire site, and then other contractors responsible for specific work that then subcontract their work out also. Sanchez versus 404 Park we cited from this court in 2019. And in this case, there is no written contract explaining what the work is. The council tells us that it's it's just an indemnification agreement. Because there is no description of the work, we have to look at the testimony. And the testimony of Lily Sirkin is, Park was a general contractor for the entirety of the project. Answer, in 2018, yes. Question, and that included demolition of the first floor and basement. Answer, yes. That's where the accident happened. That raises an issue of fact. If the court has no further questions, we'll rest on the briefs. Thank you.
Thank you.
Be very brief, Your Honors. If in fact the Park defendants were the GC in charge of the entire project, it seems like it would make a lot of sense that they, not ING, would have pulled the permits for the bathroom work and the concrete, and that they, not ING, would have retained EN, plaintiff's employer, and that it would have been they and not ING who actually supervised that demolition work. We have to look at this from a common sense perspective. And with that in mind, I just wanted to add extremely briefly that we argue that all cross claims against Park should be dismissed. First of all, as has been discussed, on contractual indemnification, there is no contract. On common law, we think that actually Park is entitled to common law indemnification from ING because Park wasn't negligent. ING hired plaintiff's employer. They held the DOB permit for the accident area. They placed Ron as a project manager or site manager, and he had authority to tell Ian to stop unsafe work practices. This finds authority in McCarthy v. Turner Construction. The indemnity goes one way here, in our opinion, of course, and that's ING to Park.
That's what we'll consider all opinions. Thank you very much.
Thank you, Your Honor.
And briefly, I just want to touch upon Labor Law 200 because I didn't get to speak on it too much at first. So we just want to reiterate that this is a means and methods case and not dangerous condition. And in a similar vein to my opening argument, the work he was performing there wasn't a dangerous condition or a hazard because the specific condition was inherent to the demolition. So the removal of the floor was related to the means and methods of the work.
Isn't Bastarek, the new Court of Appeals case, saying, it says the opposite, that you have to provide a reasonable method for the workers to be able to be safe? If there's no other method, then Bastarek would say integral to the work.
Sorry, could you repeat the name of the case?
Bastarek is contrary to what you just said. It's a Court of Appeals case that says that integral to the work is dependent upon safety of the workers in case there can be no other way, then you're correct. But if there's any possible way to safeguard the workers, Bastarek, in a new case just last year, stated that integral to the work doctrine defense will not be applicable.
All right, I'll rest on my brief then, the reasoning of my brief. Thank you.
Thank you.